Yes.
Application.
Your Lordship, may I be permitted to mention one matter for inclusion in the list, mentioning for admission hearing, Your Lordship.
Yes. Order 41, Rule 11.
My lord, application.
Please.
Your Lordship, may I be permitted to mention a matter? This is a matter under Order 41, Rule 11. The matter had earlier appeared in your Lordship's list, but back then your Lordship did not have determination to admit the appeal. Thereafter, the matter was heard by Justice Harish Tandon for extensively for 2 days. It appeared under 4 orders. However, due to the change of determination, we had mentioned the matter before Justice Harish Tandon. However, the determination now lies with your Lordship. Your Lordship, there is a certain urgency in this matter. If your Lordship can kindly.
What is the stage of the matter?
For admission, Your Lordship.
Yes.
My lord, may I permit you to mention?
No. Yes.
But in case article item 32 is not reached today, Lordship will kindly not take it up tomorrow and day after, Wednesday and Thursday, because I may not come to court for personal.
Mr. Lahiri, just ask some of your learned juniors to mention the matter. We'll grant them.
Yes.
When it is called on.
He'll remind your Lordship.
Yes, yes.
May I permit to mention on my
No, let us come from that side now. Yes.
my lord, petitioner is a senior citizen and it's a execution. It was a execution.
What are you mentioning?
Huh?
What are you mentioning? Application?
My lord, application.
Application? Yes.
My lord, may I permit you to mention Order 41 Rule 11?
Yes.
But the urgency hearing of application for police help has been fixed for.
Did not say the entire thing. Hand over. Yes.
Application.
Yes.
May I permit to mention one matter? I am disposal from my own shop room. It's the
What is this? An application or what?
application? Admission.
Admission. Yes. Yes.
Yeah, yes, other side.
Yes.
Yesterday I mentioned this matter before, my lord.
Yes, Mr. Vasu.
I was hurriedly going through the record. Lord, it appears to me that there is a delay of 19 days, but I don't find any application in the record. But I don't think my lord has committed a mistake by showing that I cannot say. That's why we, my lord, check it and be sure. In the memorandum, 19 days delay has been reported.
19 days. Delay of 19.
Yes, but I don't find any application in the record and no order.
Wait for the other side.
My lord, I have served.
Really, my lord.
Yes.
My lord, Mr. Tonmoy Mukherjee argued this matter.
Maybe.
No, I will.
Kindly hear.
I am not on that. I'm not on merit.
He is in
Kumbho.
Kumbho.
Yeah, yes.
Maybe in Kumbho, but if the section 5 was not allowed, then
No, not only that one. The appeal is against an ad interim order.
yes.
When the matter was taken up for hearing, the main 39(1)(2) application has been rejected. That has not been reported to my lord. No appeal against that order.
My lord, at the time of hearing,
Then you have to recall this order.
my lord, at the time of hearing, I was not informed. And after being informed, I asked to my client. And my lord, my client informed me through email also. He was not also aware regarding the order passed before the Honorable Harnett City Court, City Civil Court on 17 January. That is the
Maybe,
gross
but if the
mistake
position-
in our part, my lord.
If the
my
position
lord-
stand,
My lord.
then we have to recall the order because in any event, if there is a delay, how can we?
And my lord, yes, my lord.
Section 5 pe kano koriস নি?
Any section 5 has been filed, we don't even know that.
Fine. That's why I personally checked the record. There is a report of the SAM reporter.
Yes. No. No application. We'll recall the order. Learned senior counsel appearing for the respondent. Which respondent?
1, 2, 3. 1, 2, 3.
I filed an application also, man.
Learned counsel appearing for the vacating application is there.
Yes.
There is appearing today.
And 2. Yes, that is appearing.
Learned senior counsel appearing for the respondent numbers 1, 2 and 3, while moving the vacating application, submits that the stamp reporter's report inscribed on the memorandum of appeal clearly indicates that the appeal was time barred. Full stop. However, comma, by an order dated January 20, 2025, comma, the appeal was admitted and interim orders granted without taking note of the fact that there was no pending application under Section 5 of the Limitation Act for condonation of delay in preferring the appeal. Pushed up. It is contended that in the absence of any such application or any condonation of delay, comma, the appeal was non-est in the eye of law and could not have been admitted at all. Push up next para. Secondly, comma, it is argued by learned senior counsel for the respondents stroke vacating applicants that while the challenge in the present appeal has been preferred against an ad interim order passed by the trial court, comma, prior to the passing of the order by this court, comma, the injunction application before the trial court had already been disposed of by passing final orders, and, comma, as such, comma, the ad interim order which is impugned herein merged in the final order. Pushed up. Hence, comma, in the absence of any challenge to the final order, comma, the appeal could not have been, ought not to have been entertained. Push up next para. Upon hearing learned counsel for the parties, comma, we find substance in the contention of the vacating applicants. Pushed up. On both the counts as argued by the respondent numbers 1 to 3, comma, we find that in the absence of any application for condonation of delay, comma, and or any order of this court condoning the delay in preferring the appeal, comma, the order dated January 20, 2025 is a nullity. Pushed up. That apart, comma, the question still remains as to whether the appeal ought to have been entertained if it was brought to the notice of the court that the impugned ad interim order had already merged in a final order passed by the trial court. Pushed up. Accordingly, comma, can 2 of 2025 is allowed, comma, thereby recalling the order dated January 20, 2025. Pushed up. Leave is, comma, however, comma, granted to the appellant, comma, if the appellant so deems fit, comma, to prefer an appropriate application for condonation of delay, which, comma, if filed, comma, shall be listed upon being mentioned by the appellant. No address to cost. প্রথমেই affidavit service fact to be kept on. Thanks. কত কিছু আর দেখে নেবো ডাউনলোড করবে একদম।
For the
There is a Section 5 application.
yes, sir. It was disposed of on 10th of October 2023, my lord. But I'm carrying the list of that date, my lord.
10th of October.
October 2023. So this is the list, my lord.
Wait, keep the list with you. We want to see the order. Do you have a copy of that order?
No,
You don't
my
find
lord.
any.
On the website, I have not found it, but from the case status, I found that I can one disposed of. This is the status of the web found from the website.
But we do not find any order to that effect in the records.
I have not found in the website.
It was before which court?
Before code number 236, Justice Siddhartha Roy Chaudhary. It was taken up on that date, and item number 86 was that matter. SAT 61.
Item number wouldn't prove anything.
And my lord, I have the footage of YouTube, my lord.
You have the footage of YouTube?
Yes, I'm carrying it.
That it was allowed?
Yes, ma'am.
Let us just find out from. Can you put it on a pen drive and
But I have this.
no, we want to put something on record. So you have
Then
to.
on
We'll give you leave to that effect.
my lord.
We'll put it tomorrow. Just let us find out first. Because in the records, nothing is there.
Because item number 85 and 86 both are similar nature. So after passing of 85 order, he said that same order on 86 paragraph number 4 to 14 it is described, and thereafter
But that order did not go on record. Then it's very difficult for us.
the list file, kindly see item number 85 and 86.
If it is not uploaded, then there is no record, formal record.
Then
Difficult. The application under Section 5 was served.
and they appeared, but I can show the order of 85. This is the order of 85.
85.
The previous matter. Both are same. That is why
No, what is this? SAT number is 61.
similar aspect matter.
61 was not, yes, 85 and 86, right?
Yes, 85 and 86. And while delivering the order, his lordship my lord directed that same order, paragraph number 4 to 14. Kindly, it is stated in 4 to 14.
What about the other appeal? That appeal has been admitted.
Admitted by your lordship on 6th of September, 6th of November.
What is the can of this Section 5?
Second one.
This present matter.
Present matters. First is a condonation of delay, my lord. Can 1 is condonation of
Can
delay,
1.
and second is the stay application, which was passed by your lordship.
That application also we are not finding. Yes, it is there. Section 5 application. Here also delay is 74 days.
That is, my lord, 1 minute. It's 80 something. 88 days, man. It was 88 days.
একটা কাজ করছি পুরো সার্কামস্টেন্স The matter was placed in the list today under the heading to be mentioned at the behest of the court, since after the order of admission of the appeal and the connected and the order passed in the connected application bearing can 2 of 2020 was passed on January 27, 2025, it was brought to the notice of the court that there is no order on record allowing the pending application under Section 5 of the Limitation Act in connection with the appeal, for condonation of delay in preferring the same. Push up next para. When the matter is called on for hearing today, learned counsel for the appellant submits that the application for condonation of delay in connection with the present appeal had been listed on October 10, 2023 before a learned single judge, namely Siddhartha Roy Chaudhuri J, and was allowed. Push up next para. A photocopy of the list of the said date is handed over in court, which shows that the present matter had appeared as item number 86 of the day's list, whereas a similar appeal bearing SAT 9 of 2020 had appeared as the previous item, that is item number 85. Push up next para. Learned counsel submits that after the connected condonation of delay application in respect of SAT 9 of 2020 was allowed by the learned single judge, comma, the learned single judge uh, passed an order in open court directing directing a similar order of condonation of delay in connection with SAT 61 of 2020 also to be passed in item number 86 of the said days list. Push up next para. Learned counsel hands over a server copy of the order allowing the condonation of delay in connection with SAT 9 of 2020 on October 10, 2023, comma, which is also kept on record. Push up. Learned counsel for the appellant next hands over an information slip in the form of case details obtained from this court, comma, which indicates that Can 1 of 2020 in connection with SAT 61 of 2020 is shown as disposed of. Pushed up next para. Learned counsel submits that learned counsel also has on record the video recording of the live streaming of the said date of the learned single judge corroborating his submissions regarding the condonation application in connection with the present appeal having been allowed as well. Push up next para. Thus, comma, the circumstances clearly show that although an order was passed in open court on the said date allowing the condonation application in connection with the present appeal, comma, no formal order has been recorded or uploaded on the official website of this court. Full stop. Next para. Thus, comma, the position reverts back to the day when the application was supposedly allowed, that is on October 10, 2023. Full stop. Next para. Upon a scrutiny of the records, comma, we find the application for condonation of delay as well as an affidavit of service which indicates that a copy of the said application that copies of the said application was duly served on the respondents and as such, comma, the application was otherwise ready for hearing. Push up next para. However, comma, despite being fully convinced of the truth of the submission of learned counsel for the appellant, comma, we are of the opinion that the records should be kept clear. Full stop. Accordingly, comma, since we do not find any formal order on record condoning the delay in preferring the present appeal, comma, we decide to recall the order, comma, decide the application for condonation of delay afresh, and thereafter to take up the appeal for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Next para. Accordingly, the order dated January 27, 2025, passed in SAT 61 of 2020 is hereby recalled. Full stop. Next para. We take up the application for condonation of delay bearing CAN 2674 of 2020, comma, subsequently renumbered as CAN 1 of 2020. Full stop. Upon being satisfied of the explanation for the delay in preferring the appeal, comma, we hereby allow CAN 1 of 2020, thereby condoning the delay in preferring the appeal. Push up next para. The appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Pushed up. For the sake of propriety, comma, since we have already adjudicated on the issue, comma, we are of the opinion that the order of admission dated January 27, 2025 ought to be reiterated. Whoso accordingly, comma, the present second appeal will be heard on the following substantial question of law. Whether, in view of the defendant stroke appellant being admittedly a thicker tenant, comma, the civil courts had jurisdiction to pass an eviction decree, comma, civil courts ta court had jurisdiction to pass an eviction decree, comma, in view of the Thika controller, TC Capital, being the appropriate authority in law to decide such issues. Who's up next para. We now take up CAN 2 of 2020 within bracket old number CAN 2675 of 2020, which is an application for stay of execution of all further proceedings of the connected execution case. Push up next para. In view of a strong prima facie case having been made out Since the second appeal has been admitted on a substantial question of law, comma, we grant stay of all further proceedings in title execution case number 9 of 2017 pending before the learned civil judge bracket junior division bracket close second court at Shialda district South 24 Parganas till disposal of the application full stop. Next para, however, comma, the question of imposition of occupation charges for occupying the property for occupying the property together. The question of imposition of occupation charges as a condition for such stay is left open for being decided at the final hearing of the stay application by the appropriate bench. Full stop. Next para, the appellant shall serve copies of the present application on the respondent opposite parties, indicating that the matter shall be listed before the appropriate learned single judge having determination in the monthly list of March 2025, comma, subject to the convenience of the said bench. Full stop. The affidavit in opposition, comma, if affidavit in opposition, comma, if any, shall be filed to the stay application by February 14, 2025, and reply thereto shall be filed on the next returnable date. Full stop. Next para, the other defect than delay in the appeal shall be cured by the learned advocate for the appellant within a fortnight from date. Huh? After the defects which are curable by the learned advocate for the appellant are taken care of, comma, the file be sent to the trial court for the purpose of curing the defects in respect of omissions and errors in the certified copies of the decree on appeal. Thank you. हाँ, ठीक है. We find from the office report dated January 20, 2025 that that postal cost has not yet been put in with correct postal addresses of the respondent numbers 1, 2, and 3 for service of notice of appeal by registered post with AD in compliance of the previous order of this court by the appellant. Next para. The appellant is directed to put in such postal costs within a fortnight from date. Full stop. In default, comma, the matter shall be listed next on February 13, 2025 under the heading Lawazima for final orders. Next. Lawazima for final orders, actor heading.
Item number 3.
The office report dated January 8, 2025 indicates that no cost along with amended copy of the memorandum of appeal has been filed by the learned advocate for the appellants for service of amended memo of appeal to the respondents in compliance with the court's order dated July 26, 2024. Full stop. Accordingly, the learned advocate for the appellant is directed to deposit such cost along with amended copy of the memorandum of appeal within a fortnight from date, full stop, in default, comma, the matter be listed on February 13, 2025 under the heading Lawazima for final orders.
Number 4.
And I am appealing on behalf of the respondent number 1, my lord. But the direction was passed on 1st March for deposit of service upon the respondent number 2, but till date it has not been filed and the LCR has not yet been completed.
No requisite for effecting service of notice of appeal upon the respondent 2 has been put in by the appellant till date.
Yes, my lord.
We'll give you 1 week's time for that.
For the respondent number 1.
Oh.
They are not appearing continuously, my lord, after the first day. My client is suffering. If your lordship kindly pass the appeal order.
You are for respondent number 1. Records have also not come back.
There it is not complete. LCR
We'll ask you to communicate to the learned advocate for the appellant. We'll pass an order now. From the office report dated January 8, 2025, we find that despite due communication from this court, after the trial court records were sent down, they have not yet been sent back to this court. This court after rectification, nor any communication in connection with the appeal has yet been received from the court below. Next para. Moreover, no requisite for effecting service of notice of appeal upon the respondent number 2 has yet been put in by the appellants. Next para. Accordingly, the learned advocate for the appellant is directed to put in requisites for effecting service of notice of appeal upon the respondent number 2 within a fortnight from date. The learned district judge, Howrah, shall file a report indicating as to why the records have not yet been returned to this court after rectification. Such report shall be filed with the Registrar General of this court within a fortnight from date and be tagged with the main file before the next returnable date. Next para, the learned advocate for the respondent number 1 who is appearing in court today, is requested to communicate the gist of this order to her counterpart appearing for the appellant in order to ensure compliance of the direction for putting in requisites by the appellant, at the earliest. The matter shall be listed next on February 17, 2025 under the heading Lozima Matters.
My lord, in item number 5, Mr. Shagnik Chatterjee is appearing on behalf of the appellant. My lord, he has not come to court yet, my lord. I'm praying for not today, my
No,
lord.
let us see this. What is the defect? You just remain present. If you pass any direction, communicate. Not any fault on your part, the appellant's fault. The office report dated January 22, 2025 indicates that despite repeated communications, the trial court records have not yet arrived before this court. A compliance report was sent by the learned additional district and sessions judge, first court at Barakpur within bracket in charge on January 18, 2025, stating that as the case records were severely damaged by termite and water leakage from the roof, and as the Barakpur court premises were shifted to a new court building, the trial court records could not till then be traced out. Next para. However, there is no subsequent report before this court as to the whereabouts of such records. Next para. Accordingly, the learned additional district judge, Barakpur, district North 24 Parganas, and or any other judicial officer in charge of the said court shall furnish a further up-to-date report indicating the current status of the records and also endeavor to send such records to this court at the earliest. Such report shall be filed with the Registrar General of this court within 4 weeks from date. The matter shall be listed in the monthly combined list of cases for the month of March 2025 under the same heading. Thank
My lord, I have, my lord, already submitted before the learned Lojima court that the, my lord, appellant not interested to proceed with there. And my lord, send before your lordship.
Just give us half a minute, we'll just see that.
My lord.
Oh, the Lojima court could not pass that order.
My
So we are recording it.
My lord.
He still does not want to proceed with the appeal. This is your written instruction.
Written instruction, my lord, I have already filed. This is the order of the Lojima court.
Acha. Learned counsel appearing for the appellant submits that the appellant is no longer willing to proceed with the appeal. Is there any connected pending application also?
No, my lord.
Very good. Accordingly, FA 44 of 2022 is dismissed for non-prosecution without any orders to cost. Interim order, if any, stands vacated. Thank you.
The Lojima court, learned original court order.
You can keep it with you also. Lojima court order ta fere din. Let it be in the record. What is the difficulty? We have a report saying that the Lojima court has sent it to us. What?
My lord, I am stepping from the applicant, my lord. The respondent number. Well, in terms of the order, my lord, I have served notice, Salurnama, everything, but the
let's just see, Mr.
paper book is not within time, but I have filed.
The postal cost written up notice form has now been filed by you.
Yes, my lord, I have served notice, my lord.
No, you have to deposit postal cost along with written up notice form for
Yes,
service of notice.
I have submitted.
By speed that you have submitted.
Yes.
What is the entry number or whatever?
Entry number, my lord. Just a minute, my lord. A16160 dated.
Just write it on a piece of paper. Ask your junior to write it on a slip of paper and hand over. And what about the paper books? You have to file paper books. 8 copies of paper books.
Paper books, my lord, I have filed.
Oh yes, you have filed. So only the service on respondent number 2 is required.
I have served notice, my lord, according to.
When did you deposit this the postal cost and written up notice form?
25/8/2022.
No. 15th of January 2025. It's the office report says postal cost along with written up notice forms have not been filed by learned advocate.
Yes, my lord, I have tried to file subsequently, but has not received, my lord. This copy has already been handed over, my lord. Kindly see.
Tried to file not received means?
Because well, they said this is not the way to.
This is not the way.
Yes,
they are right. Take this back. We'll give you 1 week's time. Put in the requisites. The office report dated January 15, 2025 indicates that postal cost along with written up notice forms for service of notice of appeal on the respondents by speed post with AD have not yet been filed by the learned advocate for the appellant as yet. Next para, in view of appearance of the respondent number 1 through learned advocate, service of such notice is dispensed with on the said respondent, the learned advocate for the appellant shall deposit postal cost along with written up notice forms for service of notice of appeal only on the respondent number 2. There are 2 respondents only.
Yes,
respondent number 2 by speed post with AD, within a week from date. The office shall take steps accordingly for service of notice on the respondent number 2 upon such deposit being made.
Okay. The paper book already I have filed.
I'll keep that with you. You can, oh, yeah, names. Paper books, that's the report. Report says paper book has been filed. We are not recording anything.
Get much.
Despite communications being duly made, the trial court records have not yet arrived before this court. Push up. There was a previous communication as long back as on June 21, 2024 by the learned judge, 6th bench, City Civil Court at Calcutta, indicating that owing to disarranged huge number of records, the case record could not be traced out and prayed for at least 2 months' time for transmitting the same. Pushed up. The said period of 2 months has long elapsed, but the records have not yet arrived before this court. Accordingly, the learned Chief Judge, City Civil Court at Calcutta, is directed to file a report as to the reason for the delay in tracing out and sending the trial court records in the matter. Such report shall be filed within 3 weeks from date with the learned Registrar General of this court and shall be tagged with the main file. Next para. That apart, the learned Chief Judge shall ensure that the records of the concerned case are sent to this court at the earliest. The matter shall next be listed in the monthly list of March 2025 under the same heading for passing further orders.
Item number 9. My lord, I appear for the appellant petition, my lord.
What is the application?
Application for, my lord, acceptance of paper book and, my lord, expeditious disposal of the appeal, my lord. Because it is rejection of the receiver's application, my lord, I have come. And
appeal was admitted?
Appeal was admitted.
When?
Kindly have a look into this application, my lord. Application number 2, my lord. Paragraph 2 and 3 I have stated. At the time of admission, my lord, direction was made that within 15th September, that should be paper book should informal paper book.
You have done that.
Yes, my lord. I have served upon the other side also, but after 22, my lord, that has not been reached, my lord. That is why I cannot file that paper book in court, and I have tried to, my lord, paragraph 3, my lord. I have tried to file this in department also for some Bengali annexures, my lord, that could not be filed. They have not accepted that.
You have to give the translated copies then.
My lord, in a hurried manner, my lord, I have filed that paper book. I prepared that paper book, and my lord, that was directed.
Let us see the Bengali documents once.
Before the court, my lord. The direction was that it should be filed before the court. That is why, my lord.
What find for us the most illegible copy? Find for us the most illegible copy according to you, which cannot be deciphered with.
There is no illegible.
Only the language is the difficulty.
This is the difficulty. They have not accepted.
নিয়ে নিচ্ছি পেপার বুকটা যদি পরে ট্রান্সলেটেড কপি দরকার থাকে সুধীরেশ্বরী ঘরে এলে তখন মুশকিল হবে না আপনি কেন মধুরেশ্বর প্রসাদ গৌরাঙ্গ কান্তে ঘরে they will direct them to
there was a direction, my lord. Kindly I have annexed that.
বাংলা পড়তে হবে গৌরাঙ্গ কান্তে এই বলছি আপনার না এটা তো আমরা তখন শুনছি না এখন অ্যাপ্লিকেশন
page 7 and 8, my lord, I have annexed that order also in this application.
Yes. So now you want these to be accepted and
my lord, kindly fix up any day for
no, you have to file the requisite number. The other paper books have been filed. Then
served, my lord. Served upon the other side.
Served upon other side? Acha, very. So what else do you want? The other side is appearing already.
Appearing, my lord, but he has not accepting my letter because he is saying that he is this Shobhik Noskor is the chamber junior of Mr. Satyajit Mondal. He died, my lord.
Yes.
And my lord, thereafter he is saying that I am not with the contact with the client. Therefore, my lord, kindly direct me. I shall serve the notice of the hearing And my lord, directly to the other side.
No,
my
then you have to put in postal cost. It has to be through the court now.
Yes, sir. What is your lordship?
Very well. The present application bearing Can 2 of 2025 has been filed by the appellant seeking leave to file the paper books before this court. Push up. Accordingly, 2 copies of paper books filed in court be kept on record. Push up. Learned counsel for the appellant submits that a copy of the paper book has already been served on the respondents. Push up. However, respondents. Push up. However, comma, subsequently, the learned advocate for the respondent is giving out that he has lost contact with his clients. Push up as such, comma, learned counsel for the appellant, comma, in a usual fairness, comma, seeks a direction for service of notice of the appeal on the respondents directly. Pushed up, next para. We find from the records that the appeal is of a short conspectus. Trial court records were directed to come.
It has come, my lord. Let me to check. My no. No, but there is no such direction. I have to check the trial court.
Was there any direction for the trial court?
No, my lord. I have annexed that order.
So we'll dispense with the trial court records. You have annexed all the main documents here.
Yes, my lord.
Plaint is there.
Yes. With the paper.
Next para. Nakib ki bolam koto chhallam. Sorry. We find from the records that the matter arises out of an order passed in connection with a receiver application. With a receiver application. Push up. Keeping in view the brief conspectus of the appeal, comma, the trial court records need not be called for and is hereby dispensed with. Push up. Next para. The paper books filed today are accepted. Full stop. Next para. The in view of the learned advocate for the respondents disowning his clients, comma, the appellant is directed to put in requisites along with written up notice form for the purpose of service of notice of appeal on the respondents directly. Push up. Such requisites shall be put in within a week from date. Push up. Next para. Can 2 of 2025 is accordingly disposed of. Push up. Liberty is granted to the appellant to mention the appeal for hearing as and when the appeal is otherwise
My lord,
ready
let
for
it be returnable within after
ready for hearing. No, we cannot do that. You have to put in postal costs. Unless service is affected, then we cannot. Otherwise, you cannot do anything. Whenever service is affected, if you keep a track, the whenever the service is affected, mention before whoever is the bench, then we can consider taking up there. We have dispensed the other things. We have dispensed with. Paper books are already filed. We have dispensed with trial court records. Only the service remains. Whenever service is affected, keep a track, mention.
My appeal. Last occasion, there was a direction to pay the deficit court fees. Has been paid, my lord.
Paid when?
It was paid on. It was on 9th of January. This is the receipt of the. Had to be paid online.
Yes, sorry. Keep it with you. That is the report also. Now sufficient, sir. The memo of appeal needs to be classified in words. What was that? Let us see the memo. What you have done. This is against what?
Against an appellate. No, this is against an original decree.
Decree
appeal.
in the nature of declaration.
Declaration and partition.
Well, you have to just write at the top of the memorandum of appeal, memorandum of appeal from original decree. Below this appellate said, just write.
I tender my. I know my. I'm sorry.
You know that.
Tender my.
Know that.
I tender my apologies.
So we'll give you leave. Do it during the right now.
Course of this day.
Right now, then.
Let the usual directions be there. The LCRs and the paper books. Let the usual direction.
So what is the application for?
Application for stay. This is a decree of declaration that the earlier judgment and decree is not binding, and the separate suit for separate cause of action for partition. Shares were declared.
No, earlier decree, what was the earlier decree?
There was a suit for partition between the legal heirs of an original owner. It was preliminary decree passed. Final decree is drawn up. After 1.5 years of the final decree, someone else came up and says that I am one of the legal heirs. I was not made a party. He said he prays for that decree, the judgment decree to be set aside, and prays for a separate, fresh partition to be. And that was allowed.
So that has been done here.
That has been done. Against that, we are before your lordship.
What is your case? He's not an heir.
Not an heir. Man, my lord, he claims to be legal heir of one of the brothers. Brother died during the earlier suit. Now her mother, the plaintiff's mother and brother, alleged, contested the suit up to final decree. They filed written statement. They did not disclose any whereabouts of this. And it is admitted. Even they prayed for dismissal of this suit by filing written statement.
But stay of all for the then
The final decree may not be drawn up without the leave of the court. That much, my
we'll
lord.
do that. Well,
I sincerely tender my apologies, my lord, for that.
No. The learned advocate for the appellant shall classify the memorandum of appeal properly at its head. Full of leave is granted to the learned advocate for the appellant for such purpose, and such correction shall be carried out in the memorandum of the appeal during the course of the day. Full of next para. The present appeal arises out of a decree declaring a previous partition decree bad in law and granting fresh partition. Full stop. Next para. Granting fresh partition and granting a fresh preliminary degree of partition. Full stop. Next para. Upon hearing learned counsel for the appellant, we are satisfied that several questions of fact and law are required to be adjudicated at the final hearing of the appeal, and as such, a prima facie case has been made out. Accordingly, the respondents, accordingly, the petitioner, the appellant, shall serve a copy of Can 1 of 2024 on the respondents, indicating that the application shall next be listed on February 24, 2025, when an affidavit of service to that effect shall be filed by the appellant. Which of next para? In the meantime, the learned trial judge shall proceed with the final decree proceedings. However, no final decree shall be drawn up without the leave of the court till disposal of the present application.
I'm grateful. Led by Mr. Hon'ble.
Mr.
Hon'ble.
You carry out the correction, please.
I'm doing
Right
it.
now. Side the correction. But make that correction in both the judges' copies. Memorandum.
Yes, my lord.
Can 1 is an application under section 5 that is appearing for the first time.
What is the other application? No other application.
No other.
The appellant shall serve copies of the application on only 1 and 2.
Yes, 3 is on my side.
The appellants shall serve a copy of the application on the defendants' respondent numbers 1 and 2, indicating that the application shall be listed for hearing on February 17, 2025, when an affidavit of service to that effect shall be filed, which of service of a copy of the application on the pro forma respondent number 3 is dispensed with for the present.
I am for the appellant.
Yes.
This appeal is directed against my lord. An order rejecting my plaint under Order 7, Rule 11, on the ground that I had not served any notice under Section 586(4) of the Kolkata Municipal.
You have not claimed any relief against the KMC? No. Let us see the plaint.
You will also kindly
Just the relief.
Page 9 of the application.
Page 9. Yes.
Page 9.
Page 9. It starts from page 9 and the prayer portion.
Prayer portion, you will also kindly look page 15 in inner page 7. What is my prayer method?
We have sought for injunction against all the defendants.
No.
Why did
Only
you?
defendant number 1. Defendant one
No,
is the landlord.
C is permanent injunction restraining the defendant, you have said. Acha, there is.
Defendant number one is the landlord. I am tenant under.
Why did you implement the KMC?
I don't know, that wasn't the word. And that to 586 forces I need not serve any notice because that is suit under section 38 of the specifically.
So the plaint, order 7 rule 11 application and objection are the only documents to be looked at. So we'll dispense with this application is for stay.
Yes.
Stay of operation would not. So we'll direct you to serve copy of the application along with the memo,
yes,
and we'll dispense with trial court records.
Yes.
And we'll direct you to prepare and file informal paper books annexing these documents only within 4 weeks. Very well. The appeal has been preferred against a deemed decree rejecting the plaint of the appellant of the plaintiff stroke appellant in a suit
for
declaration and permanent injunction. First up, the plaintiff appellant has made out a strong prima facie case as to the ground for rejection of plaint, that is non-service of notice under section 586 of the Kolkata Municipal Corporation Act 1980 is not tenable in the eye of law, since no relief has been sought against the Kolkata Municipal Corporation within the contemplation of the said provision. Full stop, next para. Be that as it may, comma, in view of the material documents being already on record, comma, we dispense with calling for the trial court records. Full stop, next para. The appellant shall serve copies of the application as well as the memorandum of appeal on all the respondents, indicating that the appeal along with the application shall be listed for hearing in the monthly list of March 2025. Full stop. For such purpose, comma, the service of notice by the appellant shall be deemed to be service of notice of the appeal on the respondents as well. Full stop. The appellant shall prepare and file the requisite number of informal paper books within 4 weeks from date, without comparing with the records. Full stop. Subject to service of notice of the appeal and the application on the respondents, comma, the appeal be deemed to be otherwise ready for hearing. We put the application along with the appeal because you have to serve.
Yes.
You are appearing also?
Yes, Lordship, only respondent number 1.
This is the main defendant one, landlord.
Yes, yes. You are not the culprit here. The KMC is the culprit. They are the culprits actually. They have been pleaded here. Anyway. So you enter your appearance and write a letter to them so that unnecessary service on you.
I have already lost caveat. They have not yet.
No. We have not found any.
Anyway, just you can give a copy. Write a letter formally that you are appearing for this, and in reciprocation, you give all the copies to him, so you save cost of service on one.
Deeply overlistening.
Yes, Mr. Ghosh, what is the matter?
Personal Lordship's order, I serve notice upon the respondent, section 5 and the other applications.
Yes.
But the postal remark which came with the remark, address is left without instruction. So since 7 years he is not being found in the address, but the petition has a contract.
You have challenged what?
I have challenged judgment and degree passed in a matrimonial suit.
No, that we understand, but you are the plaintiff.
I am for the petitioner plaintiff.
You filed the suit for divorce, that was dismissed. So he contested in the court below.
Yes.
But without service, it would be risky.
But he did not give any evidence also.
As a copy of the impugned decree, certified copy of the impugned decree carries the wrong date of judgment. So that has to be taken care of, will send. And delays of 170 is section 5. But if it has come back with address left without instruction, then this is the address at which he contested the suit. What is the reason for the delay, Mr. Ghosh?
Learned advocate for the court will inform the fate of the matrimonial suit in the month of May 2024. Immediately he applied for certified copy. It came into the hands of the petitioner in the month of July 2024. In the meantime, 170 days gone.
Only earning memo temper এসব আছে কাজ করে।
Yes, the wrong date of this.
আচ্ছা বলছি যে এই অ্যাড্রেসে যে লাস্ট নোন অ্যাড্রেসে পাঠিয়েছে এবার ম্যাট্রিমোনিয়াল থেকে
I have not reached husband and wife also.
এই ওয়াইফ হাজবেন্ডকে difficulties otherwise, matrimonial suit, he'll come back tomorrow and file a recall application and say I did not have notice, and the entire thing will be again reopened, even if you get a degree of divorce. Or we are thinking aloud.
But the 170 days it may be allowed. And
For that also we have to do that. Anyway, I allow করে দিচ্ছি। The affidavit of service and envelope filed today be kept on record. It transpires from the endorsement on the envelope that the respondent stroke addressee left without instruction. We find from the records and from the submission of learned counsel for the appellant petitioner that the service was sought to be effected at the address of the respondent husband, which was given in the code below, and in view of the fact that the husband has contested from such address, we are of the opinion that the respondent husband is deliberately avoiding service. He contested, deliberately avoiding service. Accordingly, we deem that proper service has been effected. Accordingly, we take up Can 1 of 2025 for hearing. Upon a perusal of the averments made in the application, we are satisfied with the sufficiency of the cause for delay in preferring the appeal. Accordingly, Can 1 of 2025 is allowed, thereby condoning the delay in preferring FAT 319 of 2024. The appeal is accordingly deemed to stand registered and admitted. What is this appropriate order for early hearing?
LCR may be called for, we may be
Very well. Can 2 of 2025 is an application for appropriate orders seeking expeditious hearing of this appeal. Since the appeal arises out of a matrimonial proceeding, which has its inherent urgency, Can 2 of 2025 is allowed, thereby directing the appellant to put in due requisites, written up notice form and declaration, along with postal form for service of notice of the appeal on the respondent, within a week from date. Next para, the trial court records be called for by special messenger, also to be deposited by the appellant wife within a week from date. Next para, the appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, liberty to the parties to mention the appeal for hearing as and when the same is made ready for hearing. Thank you.
I'm appealing behalf of the wife appellant, my lord.
Yes.
It's a appeal from an ex parte decree.
The section 5, we directed you to serve copy.
No, my lord, this
First
is
time.
first time.
Serve copy and come back. The appellant shall serve a copy of Can 1 of. This is the only application, or there is any other?
There's a application.
The appellant shall serve a copy of Can 1 of 2024 on the respondent, indicating that the application shall be listed for hearing on February 17, 2025, when an affidavit of service to that effect shall be filed by the appellant.
I think this is a change brief, my lord. I think the calculation of delay has been wrongly calculated by.
You want to file a supplementary affidavit then?
Well, after the service or now?
Before.
Before. Then.
On the prayer of learned counsel for the appellant, leave is granted to the appellant to file a supplementary affidavit to the application on the next returnable date. However, an advance copy of the said supplementary affidavit shall be served along with the application on the respondent. Prepare it quickly, serve both together.
Returnable date.
We have given some date, 17th February.
Item number 16.
Yes, Mr. Dattu, what is the matter?
In terms of your lordship's order, is the affidavit of service?
Proper service has been effected?
Yes.
Stamp to, yes. What is the application for?
First application,
Order 41 Rule 27 will pass the usual order. What is the other application? Can
your
to
order means, including an order for
injunction.
bringing lower court record or
No, can
special
to
basis,
can to is for injunction.
Yes.
Mr. Dattu, what does the appeal arise out of?
arise out of partisan suit.
Preliminary decree or final decree?
The suit has been dismissed on account of
Acha.
non-production of the deed, which is not within the custody of the appellant.
Acha. Where will
Naturally,
yes.
a prayer has been made that the certified copy we have already paid for.
That is your order 41 Rule 27.
Yes.
Acha. Where we will grant injunction and you have served copies of both the applications.
Both the applications.
Right. The affidavit of service filed today indicates that good service has been effected in respect of both the applications on the respondent opposite party. Full stop. Next para. Can 1 of 2024 is an application under Order 41 Rule 27 of the Code of Civil Procedure. Full stop. As per the usual norm, comma, the same is directed to be listed for hearing along with the main appeal. Full stop. Next para. Affidavit of service, if any, shall be filed within a fortnight from date. Full stop. Reply thereto, comma, if any, shall be filed within a week thereafter. Full stop. Next para. We take up, thereafter we take up for hearing can 2 of 2024, which is an application for injunction. Full stop. The appeal arises out of the dismissal of a partition suit filed by the plaintiff stroke appellant. Full stop. Since arguable questions of law and fact are involved in the appeal, comma, we are of the opinion that a strong prima facie case has been made out. Full stop. The balance of convenience and inconvenience as well as irreparable injury factors also lie in favor of grant of injunction. Full stop. Accordingly, can 2 of 2024 is allowed, comma, thereby restraining the respondent opposite party and or his men and agents from obstructing the pre-enjoyment of the appellant apostrophes ingress and egress to the suit property as well as basic amenities. Full stop. The respondents only that.
No, water supply.
All amenities
All
and basic amenities যেখানে বলেছি including water supply to the portion of the property in occupation of the plaintiff stroke appellant till disposal of the appeal. Who's up next para? The appellant shall put in due requisites, written up notice form, declaration for service of notice of the appeal on the respondent within a week from date. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 8 weeks from the date of service of arrival of the trial court records on the learned advocate for the appellant. Stop. The liberty is given to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Item number 17.
Item 17, my lord, I'm for the appellant.
Yes.
There are three applications filed, two by myself and one by the respondent. Essentially, one is the first application, the stay application. The second application is an application putting on record the terms of settlement arrived at between the parties between the appellants and the defendant and the respondent number one in the appeal.
So you have settled the matter?
We have settled the matter, my lord. Only thing is that all the respondents could not be served since the respondent number 6 had passed away. Respondent number 6 being the father of the respondent number 1. Respondent number 1 has put in the application for being substituted in place of her father.
Respondent, he's already on record.
Yes, he's already on record.
So only for recording the death.
Yes,
Death are
recording
on
the
record.
death, that's all I think.
So we have to allow that application first.
Yes.
And what is the first step? Is stay becomes
It
redundant.
becomes irrelevant because we have arrived at a settlement. We are asking for
All the parties have signed that settlement.
That's the problem, my lord. All the parties are not on record as settlement. The main dispute is between the appellants and the defendant and the respondent number 1. The remaining respondents, we have no grievance against them. We are willing to withdraw the allegations against the remaining respondents. We just have arrived at a settlement with the respondent number 1.
But there has been an adjudication by a court of law, one court of law.
Yes, my lord. There has been an adjudication.
You have made those allegations, and so you.
I am saying I am withdrawing those allegations against the remaining respondents. I am not
not only the allegations, but you are not pressing the appeal in respect of those respondents.
In respect of those respondents, I am simply seeking that the respondent number 1 and myself, and the appellants have come to a settlement. Those terms of settlement.
Can you please show us the reliefs claimed in the suit? Just
the reliefs claimed in the suit are that of declaration and injunction. Declaration that the marriage certificate is my lord, is a for false certificate, and
marriage between
the appellant number 1 and the respondent number 1.
Who is appellant number 2?
Appellant number 2 is the current wife of the appellant number 1. Essentially, I'll just give a slight background to the case. Appellant number 1 was earlier married to the respondent number 1.
Give the names, that will be easier.
Alok Sarkar and Suchetana Rai were earlier married.
Right.
They had divorced.
Right.
Alok Sarkar married the appellant number 2, which is
Avantika, yes.
Avantika Sarkar.
Yes.
Now, within the subsistence of this marriage, Suchetana Rai came forward before the employees of Alok Sarkar. Alok Sarkar is a government servant, and claimed to have remarried Alok Sarkar later on. Whereas Alok Sarkar says that he has never entered into any second marriage with the said Suchetana Rai. So essentially, the suit was filed by Alok Sarkar and Avantika Sarkar against Suchetana Rai and others.
For the others?
For the others are including the marriage registrar, the supposed witnesses to the marriage, everything.
No relief claimed.
No particular relief claimed against them. The relief claimed was for declaration that that's no such marriage had taken place.
Is not with you.
I don't have it right now, my lord.
Sometimes the reliefs are quoted in the injunction application. Let us try to find.
Yes, my lord. Unfortunately, no. I don't. I mean, the plaintiff was with me, but I don't have it. I don't have it with me as of right now.
The suit was dismissed, obviously.
The suit was dismissed.
So in any event, there would not be any. Yes, we have got the plaint. Title suit was 2420.
Yes, ma'am.
Yes. No, sorry, we have got the decree.
The decree is there.
Decree may quote sometimes the prayer. No.
Yes, ma'am.
Yes, for declaration, injunction, and recovery of damages for defamation.
Yes, ma'am.
In these cases, please try to annex the plaint, because that
I understand. That
otherwise,
was my mistake. That was my mistake.
Otherwise, if you grant this prayer of yours,
Yes,
we have to be satisfied. No, it's there. It's there. Wait. Probably a copy was handed over separate.
In the CAN application, my lord, I think I had.
No, it's a separate copy. At least in my file.
Achha. Yes, my lord, I had
Just let us.
Court had asked me for a copy of the plaint.
Yes, copy of plaint is there.
Yes,
no, this is not the plaint. It is injunction. Plaint একটা আলাদা দিয়ে রয়েছে declaration the plaintiffs legally married couple they are living in a
Yes, my lord.
This is allegation against addition. So that's why you are saying you are not pressing those allegations.
I'm not pressing those allegations, my lord. Because the substance of the dispute was the fact that the respondent number 1 claimed to be married to appellant number 1 post their divorce, while no such marriage ever took place.
So now you two and Suchetana have come to a
settlement on this.
Who has died, you said?
Respondent number 6, who is the father of the respondent number 1. And the respondent number 1 is the only legal heir of the respondent number 6.
Why did you make her false? She was a witness.
He was a witness to the case.
You did not leave the entire family.
My lord, I was not there in the lower court. I would not have made them parties at all.
Let us take up Can 3 first. Why order 20 rule 10A?
Lordship, we are seeking expunging the name of respondent number 6 from the array of respondents, Lordship. Therefore,
All right,
order
all right,
20
all
rule
right.
10.
Can 3 of 2024 is taken up first for hearing in view of the nature of the application. First up, the application has been filed for appropriate orders in the nature of one under Order 22 Rule 10 capital A of the Code of Civil Procedure. First up, the learned counsel for the appellant submits that the respondent number 1 is the daughter and heir and sole heir and legal representative of respondent number 6, comma, the latter being the father of the respondent number 1, full stop. The respondent number 6 has died during pendency of the appeal, comma, prompting the appellants to file the present application. Full stop. We find from the averments made in the application that in view of respondent number 1, comma, the sole heir and legal representative of the deceased respondent number 6 being already on record, comma, no further substitution needs to be directed. Full stop. Accordingly, Can 3 of 2024 is allowed, comma, thereby directing the name of the deceased respondent number 6 to be expunged and recording that respondent number 1, comma, the sole heir of the said deceased is already on record. Full stop. Next para. In view of the nature of the order now proposed to be passed, comma, and in view of the fact that the appeal is against the dismissal of a suit, comma, there is no scope of passing any stay order. Accordingly, Can 1 of 2023 is dismissed as not maintainable. Next para. Can 2 of 2024 is now taken up for hearing. Next para. Learned counsel for the appellants submits. You are for respondent number 1. Learned counsel for the appellants as well as learned counsel for the respondent number 1 submit that the said parties have entered into a mutual settlement and want to have the appeal disposed of in the light of such settlement. Next para. The brief conspectus of the case is that the appellant number 1 was previously married to respondent number 1, who subsequently, after the said marriage being dissolved by a decree of divorce,
yes, ma'am,
comma, the appellant number 1 entered into a nuptial bond, NUPTIL, bond with appellant number 2. Next para. Thereafter, comma, however, comma, the respondent number 1 filed a suit. Oh, sorry, that has been decreed. That's
no, my lord. The respondent number 1 never filed a suit.
Sorry, then
the respondent
you filed a suit. Sorry. Thereafter, comma, the respondent number 1 apparently gave out that she had remarried appellant number 1, Alok Sarkar, comma, which necessitated the filing of the suit, comma, bearing title suit number 2420 of 2016, comma, which is the genesis of the present appeal. In the said suit, comma, the appellants, comma, inter alia, comma, sought a declaration that the plaintiff's appellants are legally married couple and they are living as husband and wife since their marriage on December 11, 2012, solemnized under the provisions of the Special Marriage Act 1954, comma, for a further declaration that the marriage allegedly and purportedly claimed to have been solemnized and certified on August 25, 2012 between plaintiff appellant number 1 and defendant stroke respondent number 1 was never held or solemnized, comma, for a further decree of declaration that the defendant numbers 1 and 3 to 6 in collusion with each other have manufactured and procured the certificate of marriage dated August 25, 2012, as well as for other consequential reliefs. Push up next para. The appellants now submit that they want to withdraw all allegations against the respondent numbers, defendant stroke respondent numbers 2 to 6 unconditionally, and do not want to proceed any further with the appeal as against the said respondents. First up, next para, learned counsel for the appellant submits that since the main relief sought in the suit and the present appeal is between the appellants and the respondent number 1, and the other respondents were only impleaded consequentially, as proper parties, the purpose of justice would be subserved in the event the present appeal itself is disposed of in terms of the settlement arrived at between the appellants and the respondent number 1, to the effect okay, can 2 is that? To the effect that the respondent number 1 agrees, admits, and concedes that no marriage took place between the appellant number 1 and the respondent number 1 after their divorce was granted on August 30, 2011, and the respondent number 1 withdraws all claims to the contrary. Full stop. The respondent number 1 also acknowledges that her words and actions have caused hurt and loss of reputation to the appellant number 1 and 2, for which she tenders unconditional apology to the appellants, and that her unfounded claim to have been remarried with the appellant number 1 after their divorce on August 30, 2011 may unintentionally have caused irreparable loss to the reputation of the appellants, thus affecting them adversely, for which she also tenders apology to the appellants. Push up, the appellants also agree to withdraw all claims for damages against the respondents and agree to have the terms of settlement the basis for the disposal of the pending litigation, including the present appeal. Full stop. Next para. Such terms of settlement have been reduced into writing and have been annexed as Annexure A to the present application. Full stop. Next para. We find from the said terms that those are within the confines of law and in proper form. Full stop. As such, since the primary contesting parties are agreeable to have arrived, since the primary contesting parties have already arrived at a settlement, it only remains for the court to acknowledge such terms and dispose of the first appeal in terms of such settlement. Accordingly, can 2 of 2024 is allowed, thereby is 2020 allowed, as a consequence, FA 10 of 2025 is disposed of in terms of the settlement arrived at between the appellant numbers 1 and 2 and the respondent number 1 as reduced into writing and annexed as Annexure A to Can 2 of 2024, which is also treated to be a part of the present decree. Next para. Insofar as the appeal against the other respondents, being respondent numbers 2 to 5, are concerned, the appeal is deemed to stand dismissed for non-prosecution against the said respondents. Insofar as the deceased respondent number 6 is concerned, it is hereby recorded that the appellants withdraw all allegations made against the said deceased. No address to cost. Thank you.
My appeal, my lord. The wife is the appellant, assailing an ex parte judgment and decree of divorce initiated by the husband. My lord.
You didn't file order 9 rule 13?
It's there. It's separate proceedings are there. In any way, my lord.
Yes. So
One thing I have prayed for, the application is there for injunction as well as stay. I was initially trying to pray for stay injunction, but the something has dropped. This is my supplementary affidavit.
Married in between.
No. It's 3 months has not. What has happened, my lord? I have been given a notice to quit and vacate, my lord. Now I don't have any parents. There's a 11-year-old female child of the party.
Notice to quit from the matrimonial home.
I am at my matrimonial home, my lord. The summons was served upon the matrimonial home. It was somehow suppressed. That is by the other in-laws. I am at my matrimonial home with my 11-year-old female child, my lord. Some protection I'm seeking, my lord.
So have you made any prayer to that effect?
Yes, my lord, I have. Page 8 is my prayer, my lord.
Of the supplementary affidavit?
No, my lord, of the CAN application. Initially I prayed for injunction as well as stay.
You sought for injunction from remarriage?
Remarriage and stay of the impugn order, impugn judgment and decree.
No, but you have to incorporate a prayer for restraining him from. Anyway, let us see your supplementary affidavit. And you have stated that the supplementary affidavit be treated as a part and parcel of the original writ petition.
Original application.
You have written that.
My lord, it was rather prepared very hastily because it was handed to me.
We
No, my lord, I tender my apologies, my lord.
No, fully understood.
Now, one more thing, my lord, the decree was passed. Decree was passed by a court not having the initial specific marriage acts divorce proceedings had to be initiated under section 31 before the district judge. It had to be. It was to be transferred to the learned Barakpur court there.
Under Hindu Marriage Act.
Special Marriage Act. It was initiated before the Barakpur court.
Yes.
It could not have been. With the grounds of appeal, that is one of the.
The present appeal has been preferred by the defendant wife in a suit for divorce against an ex parte decree of divorce obtained by the respondent husband against her. Which of next para, we find from the records that a sufficiently strong prima facie case has been made out by the appellant for hearing of the appeal on merits, including whether the learned trial judge had jurisdiction to pass the decree. Which of next para, from the averments made in the injunction application, we find sufficient reason to restrain the respondent from remarrying during pendency of the application. Pushed up. With the leave of court, a supplementary affidavit is filed today by the appellant, where it has been disclosed that during pendency of the appeal, taking undue advantage of the impugned decree of divorce, a notice has been issued by the respondent husband to the appellant wife to leave and vacate her matrimonial residence. Full stop. A copy of the notice dated January 21, 2025 has also been annexed to the supplementary affidavit. Full stop. Next para. Accordingly, we deem the further prayer for injunction restraining the respondent from evicting the petitioner without due process of law and from acting upon the notice dated January 21, 2025 be deemed to stand incorporated in the main injunction application on the basis of the averments made in the supplementary affidavit. Full stop. Next para. The appellant shall serve copies of the application and the supplementary affidavit on the respondent, indicating that the application shall be listed for hearing on February 24, 2025, when an affidavit of service to that effect shall be filed by the appellant. Pushed up. The respondent husband shall remain restrained during pendency of the application from contracting any remarriage and from acting on or giving any effect to the notice dated January 21, 2025, annexed to the supplementary affidavit filed today, asking the appellant to leave and vacate her matrimonial residence and or from disturbing the peaceful possession of the appellant at her matrimonial residence in any manner whatsoever. Thank you.
I'm extremely grateful. Initially, there were caveats lodged so that I cannot go for protection before the Munsif and the sub-judge court. After that, the legal notice to quit came.
No, caveat was lodged by
them, so that I cannot go before a court praying for injunctions. I have made the prayer here.
You have served a copy. Caveat was lodged in the
No,
appeal.
no, my lord. Caveats were lodged before the principal civil courts, so that I cannot go pray for that I am the legal married wife and permanent injunction, so that I cannot be thrown out of the matrimonial home. Those have not been enacted.
Acha, caveat regarding any proposed suit by
Proposed
you.
suit, right, my lord. I'm extremely grateful.
Thank Yes.
It is the matter, my lord. The appellant is the petitioner before lordships.
Right.
My lord, this is a case, my lord. The land was acquired by the government for the purpose of, my lord, Bardhaman housing complex. And initially, my lord, the proceeding was started by initiating by, my lord, publishing notification under section 3, my lord, that is, my lord, for requisition under section 4(1)(a) of the 1948 Act.
That enhancement.
At
You
the,
have
yes, at the, my lord, the award was not, my lord, passed within the statutory period of 1948 Act. As because the act, the lifetime,
So the executing court has already directed you to set apart the awarded amount.
Awarded amount.
So that is still there.
That is still there. And also, my lord, we have.
We will make that order. We'll say that in view of that order, we are not passing any further order, but we'll ensure that this amount is kept set aside during pendency of the present appeal also. We will do that. We will dispose of the application in this manner.
This so far the amount should be deposited, otherwise lordships.
Amount has not been set apart. It has been set apart by them.
We have separated.
Interest included from the general profit and loss. No, you not only set apart, but you will also have to put it in an interest-bearing account and disclose the details of the account to them, as well as to the court. Instead of depositing with the registrar and the registrar taking the trouble, we'll direct them there. The state, so, and they'll disclose the account details to you.
Last matters can be given to the deposit to the register.
This is a special case because here you have already got an order from the executive court.
Yes, that should be not yet been deposited. That's true, my lord.
No, not deposited. It was set aside. So yes, what is the difficulty in depositing with the registrar? That will be easier. Do it through the registrar.
With our honorable High Court, my lord.
Registrar of this court.
Yes.
Well, that will be easier for all of us.
All
you
of us.
also.
Yes, all of us. Yes.
Very.
All the orders side.
The matter had been adjourned previously to enable learned advocate for the appellants to take instruction. Full stop. The learned advocate for the appellant hands over a compliance report dated February 22, 2024, from which it is evident that by virtue of an order passed by the executing court, the awarded enhanced amount of rupees 58,09,962 has been set apart by the appellants from the profit and loss account with scheme ID -4877. Next para. Since we are convinced that a prima facie case has been made out in the appeal, the same is required to be heard. Accordingly, Can 2 of 2024 is allowed, disposed of, thereby granting stay of operation of the impugned award, subject to the appellant depositing the set apart awarded amount of rupees 58,09,962 with the learned registrar general of this court within 4 weeks from date. Next para. Upon such deposit being made, the learned registrar general shall deposit such amount in an interest-bearing account. The said deposit shall be subject to the outcome of the present appeal. This much?
Paper direction.
My lord, in place of 4 weeks, my lord, but this is government.
4 weeks is sufficient.
Yes, ma'am.
4 weeks. We have not granted 1 or 2 weeks. 4 weeks is no election, nothing.
Nothing.
Very well. Next para. In view of you are for all the respondents.
I am the decree holder, land loser.
Who are the other respondents?
Other respondents that BDA.
My lord, that is requiring body, my lord.
That is the requiring body.
Requiring body.
They are also required to be served. They are required to be heard. Did they contest in the court below?
No, no.
Then we are dispensing with service only.
Yes, ma'am.
In view of the appearance of the contesting respondent number 1, comma, service of notice of appeal on the said respondent is dispensed with, full stop. In view of the nature of the challenge, comma, service of notice on the other respondents is dispensed with as well, full stop. The appeal be treated to be ready as regards service. Full stop. The appellant, the trial court records shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a fortnight from date, full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Next para, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. আরেকটা লাইন অ্যাড করি যে the document filed today, the compliance report filed today by the appellant be kept on record.
The next matter is the same, only the figure is the.
My lord, next matter, there is no such, my lord, order from the lower court below to set apart the set amount from the, my lord, department.
20?
Yes, my lord, 20. That's why, my lord, the amount has not yet been, my lord, set apart.
That is all the
So I
We will direct that amount to be deposited directly.
that matter is required to be, my lord, hard out, my lord. Otherwise, my lord.
We will come back in 5 minutes and we'll hear. There's a delay.
Delay has been called, my lord.
Has been gone.
My lord, in this case, my lord, initially, my lord, we pass an award after taking into account the assessment of the, my lord, land and also the other, my lord, considering the, my lord, development, considering the vicinity, considering the, my lord, area, considering the situation. We, my lord, initially paid rupees 71,000 as an award. My lord, under section 12 of the, my lord, Land Acquisition Act 1894. Although but it was started 1948 Act because the award was not passed within the statutory time.
Here also the amount is same.
Yeah, only here, my lord, what has happened? The
amount is not same.
Not that is
5809,962.
No.
Yes,
That
that
is
is
38 lakh.
Initial amount 38 lakh something.
38 lakh something.
Total amount 38 lakhs 51,410 on
এই অর্ডারটা যেটা কপি
December
রয়েছে
2013.
এটা FA 72 বলে রয়েছে। এই অর্ডারটা এখানে রয়েছে। এটা তাহলে অন্য ম্যাটারটা অর্ডারটা ঢুকে গেছে নাকি না ফাইলটা ঢুকে গেছে? দেখুন না তা না অর্ডারটা যেটা total amount here?
My lord, digital amount 71 lakhs, 71 lakhs only. Sorry, my lord, 71,000. 71,000, 500, digital amount 38 lakhs. Our award is 71,000. Enhancement amount 38 lakhs.
18 reference 38 lakhs 51,410 on 31st December 2013.
38 lakhs.
And kindly see the stay
And my
application.
lord, the petitioner received
stay application
71,514.
Which
as
paragraph?
this award.
Paragraph 10, page annexer, page 4 of the stay application. They have stated.
Yes, yes. 5321,860.
That is calculated amount. They have stated.
Yes, yes. So direct you to deposit this with the Registrar General, as in all matters.
My lord, this my amount has not yet been sanctioned by the government. So I pray your lordship, my lord, because this is the land of the Sali land. My lord, the honorable court below, my lord, what I am humbly.
We are not waiting for the government to sanction anything. We'll pass a direction that you will deposit this amount within a particular period.
So, my lord, it cannot be, my lord. I just humbly pray within that period, my lord, the amount.
What period?
My lord, the period your lordship would fix, my lord.
Yes.
The amount has not yet been sanctioned by the, my lord.
Have it sanctioned by the order of the court?
Lord, here is the delay 3,326 days has been condoned.
The present appeal has been preferred against the enhancement of compensation payable to the contesting respondent. Full stop, next para. Upon hearing learned counsel for the parties, Can 2 of 2024 is disposed of by granting stay of the impugned enhancement award, subject to deposit of the awarded amount of rupees 53,21,860 by the appellant with the learned Registrar General of this court within 4 weeks from date. Next para. Such deposit, as and when made, shall be invested in an interest-bearing account by the learned Registrar General, subject to the outcome of the appeal. Yes.
My lord, in this case, my lord,
4 weeks is sufficient.
My lord, as because the amount has not been sanctioned, so I, my lord, kindly give me some, my lord,
Get it sanctioned and file.
More time, my lord, because I have been told by our department also, my lord.
4 weeks is sufficient.
My lord, kindly make it 6 weeks, my lord, your lordship, my lord.
The appellant shall, in view of appearance of the main contesting respondent through advocates, service of notice on the said advocate, said respondent is dispensed with. The other respondents, service on the other respondents is also dispensed with. Full stop. The appeal be treated to be ready as regards service. The appellant shall prepare and file the requisite number of asana. The records shall be brought by special messenger at the cost of the appellant to be deposited within a fortnight from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list for hearing as and when the same is ready for hearing. We are granting you 6 weeks,
Yes,
not 4 weeks.
get
We are granting you 6 weeks. এখানে যেটা প্রথমেই 4 weeks দিয়েছিলাম ওটা 6 weeks করে দিই। আগের ম্যাটারটা 4 ওটা তো হয়ে গেছে, এইটা শুধু 6 আলাদা আলাদা অর্ডার, এটা আলাদা অর্ডার হলো। আমি তো আলাদা অর্ডারই পাস করলাম, অ্যাপিলটা আলাদা আলাদা ইয়ে করে না, একই লোক রি করে লিস্টে একসঙ্গে আছে। হ্যাঁ, তাহলে রি করে করে আলাদা অ্যাপিল করে দেবে। এটা 6 weeks, ওটা ওটা যা আছে।
Item number 21. For the appellant petition, my lord.
Yes.
In terms of the last order, my lord, I have served upon the respondents, my lord, here the affidavit of service. That the supplementary affidavit was filed on an earlier date, my lord, whereby your lordships queried that what is the admitted due, my lord, we have.
So what is the matter arising out of?
My lord, arising out of an compensation granted by the Employees Compensation Commission in respect of an
Please use the microphone.
My lord, I'm sorry, my lord. My lord, the Employees Compensation Commission, my lord, granted award in respect of.
Oh, you are the insurance company.
Yes, my lord.
The quantum of interest.
No, not interest, my lord.
This is not.
This 50% was allotted in respect of considering that the injury that was caused to the claimant is of permanent disablement. And my lord, there is a schedule in the act which shows, my lord, what is the nature of injury for which 50% may be included. My lord, if your lordship kindly takes up can 1 once. My lord, page 12. Can 1.
Can 1 is a condonation application.
No, can 1
Can
is
2 is a.
I am sorry, my lord, can 2. Page 12.
Yes, page.
My lord, this is the medical certificate issued by a medical examiner, my lord.
This was produced by them.
Yes, my lord. At the last, my lord, after
history take up.
So we take it up,
Taken up.
medical examination and such, the medical documents. I am of the opinion that the PT has suffered permanent partial disability to the extent of 25% due to the painful stiffness of the elbow joint with restricted movement
and weakness.
That was the observation of the medical examination. Now it comes to page 15 of the application. That is the order of the commission. Page 15, 15.
Yes.
At the very first paragraph, if you also will find, I find that the applicant has, was admitted to hospital on such and such. From Exhibit 6, the evidence of PW2, it is established that the patient has suffered permanent partial disability to the extent of 25% due to painful stiffness of the right elbow joint with restricted movement and weak such and such. Any work with right arm. Interestingly, PW2 was given suggestion that the patient did not suffer permanent partial disability to the extent of 25% and loss of earning capacity of the 100%. Obviously, she denied the suggestion. However, as per claim case, applicant loss of earning capacity of 50%. So the cross-examination of PW, it is established that he has lost 50%. This is where we are aggrieved with, because this is.
No, earning capacity is directly proportional to the disability percent.
There is a schedule, which provides.
Have you got any copy of that schedule?
Yes, I have the book.
Just indicate the relevant paragraph.
I only have one book.
No difficulty. It's like there's a chart.
Yes,
of what would be the.
Yes, this is the chart, This is the nature of injury. And
so 25%, find out 25% disability.
25% is separate, If your lordship kindly have a look at section 4, it will explain everything. This will explain everything. %25%.
Total permanent partial disability. So this is in which schedule?
There, it is as per the order. It is falling in B, but to our extent, it will fall in C, because this is not a permanent in nature. Because the schedule doesn't provide 50% can only be awarded in case of any amputation or loss of limb or finger or anything of that nature. That is what the schedule says. But here there is no loss of any part of the body, only stiffness in the elbow, and there is restriction.
No, 50% and 20% both would not be permanent partial disablement. Both would be partial permanent disablement.
Well, as per the examination, that would be. But so far, the loss of 50% earning capacity, that is the issue.
How do we correlate the two? I mean,
Well,
from which provision? That is what we are.
If your lordship kindly takes up the award once, at the last, it is established that the petitioner has lost earning capacity to the tune of 50% too. That was not an observation of the examiner. The observation of the examiner was that permanent partial disability to the extent of 25% and loss of earning capacity to the 100% is the claimant's claim. Now that has to be in accordance with the.
No, is the percentage of loss earning proportional with the percentage of disability? It is not.
No, the schedule has given what kind of injury there shall be the percentage of loss of earning capacity. But this injury does not fall to that capacity.
So according to you, this injury should fall under which? It's
to us, it should be within C because this is not permanent in nature, but
permanent partial disablement. C is
permanent
temporary disablement. You are saying?
Yes, because stiffness in elbow, my lord.
But the nature is permanent. Let us see that.
Page 12, my lord.
Permanence is not decided by the nature of injury.
I can understand that is a difficulty, but so far as
suffered paramount permanent partial disability বলেছে of 25%. তাহলে permanent partial disability হলে এটা আসছে.
It attracts B, my lord.
Whether earning capacity would be affected?
No, B is where permanent total disablement results from the injury. This is not that. He has said permanent partial disability, which comes under C. C is in case of an injury specified in Part 2 of Schedule 1, such percentage of the compensation which would have. So this has not been given in consonance with C.
No, that is our point, my lord, because if that would have been, it would be in terms of the schedule.
Acha, the schedule has not been considered at all.
Yes, that is because in the schedule says for having a loss of 50% permanent earning capacity, there has to be an amputation or loss of any parts of the body. If your lordship kindly have a look at the schedule.
Part 2 of Schedule 1. Part 2 of Schedule.
Part 1 is for 100%. Part
yes, we are not
Part 2 is.
Part 2 of Schedule 1.
Kindly sees the 50% at the right side, my lord. What are the nature of injuries, my lord?
আচ্ছা আচ্ছা একদম টোটালি চলে গিলোটিন অ্যাম্পুটেশন অফ দ্য তাহলে এটা কিসের প্রফেশন very well so
but we have subs wise, my lord, they are not appearing, my lord.
The appeal was formally admitted.
Yes, my lord. Your lordship on 23rd December, your lordship please pass now.
But total stay cannot be granted. I mean, then I have to deposit the amount.
That has already been deposited before the commission, as per that is a prerequisite of the act. My lord, if your lordship kindly takes up page 23rd December order of your lordship, my lord.
Oh.
Second page. That is the reason your lordship stayed it.
Oh, what? So you have to file a supplementary affidavit.
I have already filed on the last.
Oh, what are your admitted dues? We'll look into that.
Page 2, my lord. 1,20,996.
তাহলে এইটুকুনি অ্যামাউন্ট ওকে উইথড্র করতে দেবে বাকিটা থাক হ্যাঁ ডিপোজিট করেছে সে হ্যাঁ পুরোটাই ডিপোজিট করেছে so we'll permit them to withdraw this admitted amount for the present and we'll make the stay absolute till disposal of the appeal.
Okay.
You are filing the supplementary affidavit today?
No,
Previously you filed. Now service was to be effected on the other side. You have filed affidavit service today. Good service effected.
On both owner and the claimant.
From the affidavit of service, it is clear that good service has been effected on the respondents. Full stop, next para. Learned counsel for the appellant raises an issue as to whether, despite the expression within double inverted permanent partial disablement, double inverted clause, used in the prescription relied on by the claimant, the present in the injury of the said respondent comes within the ambit of double inverted মধ্যে permanent partial disablement double inverted clause as provided in section 4 within bracket 1 within bracket small c within bracket small I comma read with part capital II of schedule capital I of the Employees Compensation Act 1923. Full stop. Since the appellant has made out a strong prima facie case for hearing of the appeal on merits, the impugned award is stayed till disposal of the appeal, impugned order is stayed till disposal of the appeal, full stop. Since the appellant has already deposited the awarded amount with the learned registrar general of this court,
before the learned
with the commissioner, was there any direction for that to be put in some fixed deposit?
No, my lord, it is a prerequisite. I have to deposit there and then come before your lord.
We permit the respondent number 1 is the main, or both respondents?
Yodu Gopal.
We permit respondent number 1 to withdraw the amount of rupees 1,20,996, which according to the supplementary affidavit filed today is the amount of compensation which is admittedly disbursable to the respondent number 1, who's up as and when the respondent number 1 approaches the commissioner, employees compensation, West Bengal, the said admitted amount of rupees 1,20,996 shall be disbursed to the respondent number 1, subject to the outcome of the appeal and without prejudice to the rights and conditions of the parties. Who's up next para? Can 2 of twenty 2024 is accordingly disposed of. Push up next para. The appellant shall put in due requisites for service of notice of appeal on the respondents. Push up the records be called for by special messenger at the cost of the appellant, also to be deposited within a week from date. Push up. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the appeal on the learned advocate for the appellant. Full stop, next para. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you very much. রেজিস্টার্ড হয়েছে অ্যাডমিট হয়নি সাবস্টিটিউশনও আছে এনিওয়ে কেউ অ্যাপিয়ার করছে না এখন of call. Let the matter stand adjourned for the day.
So I'm appearing on behalf of the appellant.
Mr. Raj, the two are connected appeals.
Yes.
দুটো ফাইল এখানে আছে
Yes, yes, both the files are there. But
Right.
in a suit for declaration in
What is the defect?
Yes, the first defect is that certificate is not given in the memo. It is to certify that the
So you haven't no leave was given to you to correct?
Lordship, actually Priyanka Mondoli is appearing, he's the advocate and record. Due to his father's illness, she is not coming to court. I called her, she will be available next week after Wednesday.
Should you take it up next week then? Or
Lordship. And Lordship, one defect is in, there is one defect. Another, there is a section 5 application. What has happened, Lordship? Suit for declaration and injunction. Suit was decreed partly. A schedule was decreed in my favor. B schedule was not decreed.
No, section 5. What about the section 5?
They are coming to that. The respondent filed an appeal. I filed a cross appeal. So that cross appeal was allowed. My A schedule was also given a go by. No, I am not entitled to A schedule property. Against that, I have come up before His Lordship. The matter came up before His Lordship, the Honorable Mr. Horish Tandon and Honorable Mr. Hiranmay Bhattacharya. Then they pointed out you have to file another appeal. Because cross appeal, so second, another appeal was filed. That is,
these are the two appeals.
These are the two appeals from the same judgment.
So what about section 5?
Because the second appeal was filed beyond the period of limitation, therefore I have to file a section 5 application.
File it then.
I have filed the section 5. Let me serve copy.
Stamp reporter's report does not indicate anything about the delay.
Delay. Second matter, there is a delay.
Second matter, what is the number? City number?
206 of 2019.
24. Item number 24.
Yes.
Delayed by 104 days.
Yes. And this is the learned second judge's copy of section 5.
Yes. So you have to serve a copy and come back.
That order, your Lordship will kindly pass that order.
What is the can?
1.
And is appearing?
Yes. Appearing.
Right. And 3 is stay. Can 3?
Stay.
Very well. No, can 3 is in the other one.
Other one. Only one can. Can one.
Very well. Very well. We will grant you, we'll direct you to serve copy of the section 5 and direct the defect to be cured by within a fortnight. Which will come back up. Very well. The learned advocate and record for the appellant shall cure the defect as pointed out in the memorandum, as pointed out by the stamp reporter, by putting in the requisite certificate in the memoranda of appeal in both the matters within a fortnight from date. Full stop. Next para. The appellant shall serve copies of Can 1 of 2021 on the respondents, indicating that the said application be listed along with the appeal for hearing of the application as well as the appeal under Order 41 Rule 11 of the Code of Civil Procedure on February 17, 2025, when an affidavit of service to that effect shall be filed by the applicant. Cure the defects in the meantime and serve copies.
Yes. This is regarding the family settlement. I had addressed your Lordship on the last day. The aspect of will has to be considered. I was beseeching my lord, my senior wanted to make some submissions. He is on legs. Can it be taken any other day?
Hard matters, Mr. Shen, very difficult. Your senior will always be on legs. In some other
He will have to conclude. I am ready, but he wants to do, my lord. He said that just make it not today. He'll come back. And tomorrow we'll keep it.
What do you say? Yes. An adjournment is sought
Lordship, only
I had made the submission only the will aspect. It is not a family. Your lordship was not with me regarding this. Does not create a right in present time. So it has to be controlled. What will the effect if it's held to be a will? Either it's a family settlement or a will. What will be the effect? If
Yes,
it's
you're
a,
saying something.
only instead of tomorrow, if it can be day after tomorrow. Tomorrow a fixed matter is there. I might.
Day after tomorrow, if Mr. Senior, my senior is not there, my lord, I'll finish whatever.
Well, an adjournment is sought on behalf of the appellant. Let the matter stand adjourned till January 30, 2025.
I'm grateful.
Thank you.
Article number 26.
Before the respondent.
Yes.
But yesterday I was rather weird on the written statement. My lord,
Mr. Dey, we would request you to just be precise on the arguments because there are so many pending appeals. I mean, make your submissions. We are not wanting to curtail you because we also learned the law from seniors like you. But Mr. Dey, please just make it as precise as possible because we are because otherwise we already can't see that side of the advocates. Now this side will also be covered.
This is the only bench. What?
The difficulty is that so many appeals have already been we have listed and their records are here.
Yes.
So we want to dispose of as fast as humanly possible.
No, on the
Written
yesterday, my lord, I was drawing your lordship's
Yes.
attention
Yes.
to Order 6, Rule 14 and Order 29 and also Section 34 of the Companies Act with regard to the written statement regarding the signature of the
Absolutely.
person who has signed the written statement.
Mhm.
Now, in this context, I was drawing your lordship attention to the list of the documents they have relied upon and which is usually given at the end of the pleadings in case of plaint and written statement.
Yes.
And that was, my lord,
Wrongly mentioned as plaint.
my lord.
At the end of the written statement, it was wrongly mentioned.
Yes, wrongly.
Plain-
I am careful, my lord. Your lordship.
We remember this.
Now, my lord, so we are not finding any sort of paper showing
Regarding his
that there
authority.
was any resolution authorizing
Right.
him to sign.
Right.
But, my lord, it is my duty to draw your lordship's kind attention that there is one paper. Ultimately, it is coming out. My lord, that is, my lord, in this context, my lord, let us consider that paper. Whether that paper can, my lord,
Suffice.
cure the defect.
Yes.
Now, my lord, that is, my lord, my lord, that is in part 2, my lord, page 250.
Yes.
What has got it? My lord?
Yes.
Well, this is coming when the witness Subroto Datta, who has signed the my lord written statement, he was in the box.
All right.
And it was produced, and he has proved it. Now, my lord, this authorization letter, we are it is dated on 26th day of November 2015. Well, the written statement was filed sometimes in the year 2011.
So post facto.
Anyway, my lord, still, my lord, still, had there been any indication ratifying the earlier act, then also, my lord, I can say it is cured is defect. The defect is cured, my lord. But, my lord, you logically see the resolution. It is absolutely prospective resolution. My lord, I'm just, my lord, reading it out, my lord. Resolved that
Mr. Subroto Datta, Vice President and of Mageva Bridge Products Private Limited, the company, be and is hereby authorized. I'm putting emphasis on this word, hereby authorized, to represent the company and to appear, conduct, defend, depose before the landed 9th Court Civil Judge Senior Division at Alipur in Manishut number such and such, etc. etc. Resolve further that Mr. Subroto Datta, Vice President of the company, be and is hereby authorized to sign, verify, and affirm on behalf of the company, Bokasnama applications, petitions, affidavit, appeals, and other pleadings, and all other necessary documents and papers as may be required to be filed before the landed 9th Court Civil Judge, Senior Division Alipur, or any other court of law, including the Court of Appeal Division, etc., in this regard, from time to time, and to represent the company either himself or through advocates before the said court and or any other court of law, and give evidence.
Yes, Mr. Dev, we have seen it. Prospective.
It
To
is
be
prospective.
filed and hereby authorized.
Hereby.
From that.
But there is not
Prior
even,
ratification.
not even a few words that we ratify all the acts done by him. In that case, my lord, that case could have been
Cured.
That
Might have
could
been.
might have been. My lord.
Yes.
Anyhow, my lord, it is absolutely blank, my lord. So 2011, there was no authority, and even after that, there was no authority till today, my lord.
No, this is there.
But there is no authority up to this 2015.
Yes. After that, there is.
Yes. After this 26th day of November 2015, he can do it.
But if the filing of the pleadings is improper, then we should, according to vitiate the entire thing. Because if there is no basis of pleading, evidence cannot be looked into.
Evidence cannot be looked into. That is established now, my lord. Even very recent judgment, a few days, 2-3 days back, my lord, Supreme Court has delivered a judgment. Got it, my lord. There no pleading, no evidence. No pleading, no evidence. And if the written statement is not there, my lord, in that case, my lord, I will be submitting, my lord, that the provisions of Order 8 Rule 10 will be attracted. Order 8 Rule 10, my lord, kindly remember. If there be no written statement, then court is free to pass a judgment on the basis of the pleading, plaintiff's pleading. But I am relying upon my lord, Order 8 Rule 10.
Yes.
This is one aspect of the matter. My lord, another aspect is this, my lord, if we take it for granted, yes, there is written statement. If we take it for granted, yes, there is written statement.
Yes.
Now, my lord, in the written statement, you will also kindly see. The defense which they have taken before the company court, the same defense is being taken in the written statement. My lord, it is of course, my lord, it is obvious. They will take
Yes, obviously.
the same defense. Now, my lord, my lord, I'm not going to read the entire defense. My lord, I'm just, my lord, pointing out the relevant portions dealing with those allegations which they have raised before the company court. My lord, you will also kindly come to paragraph 7 at page 19.
Yes.
My lord, I'm not reading the entire paragraph. My lord, kindly come to the bottom 1, 2, 3, 4, fourth line. The supplies are made. Has you also got it?
Yes.
The supplies are made by the plaintiff against orders placed by the defendant from time to time. Or at all material times, the plaintiff was well aware that Subroto Datta used to look after and supervise execution of manufacturing activities. And works relating thereto, while Tarugnath Mitra, who was then a director of the defendant, used to look after and supervise all the accounts, finance, and purchases of the defendant, including sanctioning of the bills of the suppliers with the authority to sign, to singly sign the checks on behalf of the defendant. It is his defense. Now, the next paragraph. It came to light that the said Tarugnath Mitra, in collusion and conspiracy with the certain suppliers, was siphoning away the funds of the defendant by making payment of fictitious and fabricated bills reportedly raised on the basis of fictitious and fabricated challans of such suppliers, showing purported delivery of purported materials without such materials being either ordered by or delivered to the defendant. My lord, pausing here for a moment. This statement indicates, my lord, indicates not the defendants. suppliers. He is trying to ventilate the usual practice of Tarangnath Mitra.
Not the plaintiff.
Not the plaintiff. Plaintiff's name is not appearing here. Then, my lord, such siphoned monies were evidently being shared by the said Tarangnath Mitra with the concerned suppliers. For example, if a particular supplier supplied goods to the defendant and raised 5 genuine bills for such supplies, 2 additional fictitious and fabricated bills with corresponding additional fictitious and fabricated challans would be raised on the defendant by the said supplier in collusion and conspiracy with the said Tarangnath Mitra without any supplies having been made to the defendant in respect of the same.
So no specific allegation against you.
He's trying to raise the practice. It also transpired that false and fabricated documents are being manufactured by the said Tarangnath Mitra in collusion and conspiracy with such suppliers relating to such fictitious bills, and the said Tarangnath Mitra would sanction and made payment to such suppliers for both genuine bills as also fictitious and fabricated bills. Such checks are signed only by Tarangnath Mitra. Neither the defendant nor other directors were of such siphoning of the funds. In view of the apostate, it becomes necessary for Subrata Datta to part ways with the said Tarangnath Mitra and his family and associates, etc., associates who ultimately transferred all their shareholding in the defendant in favor of Subrata Datta and his wife Srimati Malaya Datta. The said Tarangnath Mitra also resigned as a director of the defendant with effect from 19 July 2007. This is very important. July 19, 2007. And this was informed to the defendant banks immediately by the defendants and necessary steps are taken accordingly. Suddenly, in June 2008, the plaintiff by letter dated something. This is relating to our demand notice. They are saying. Now, then he says, after that the following bills are also the challans and other documents related to the same these are the fictitious bills. Now it is coming. The following bills, as also the challans and or other documents relating to the same, are fictitious and fabricated, herein referred to as the said fabricated bills, and the same are not payable by the defendant. He has given a list of the fabricated bills, which are, I think, 12 in numbers. Then now kindly come to next page, page 23. Although the said fabricated bills are purportedly issued in January 2006 to August 2007, the demand for the same was made for the first time after more than 1 year in June 2008. No orders were ever placed by the defendant in the said plaintiff in respect of the goods purportedly delivered by the said plaintiff under the fabricated bills. No supplies were made by the said plaintiff to the defendant, and no goods were received or consumed by the defendant in respect of the said fabricated bills. Well, this is very specific statement. The purported signatures of the said fabricated bills under the delivery challenge are not of any authorized personnel of the defendant, and such purported signatures have evidently been forged and fabricated by the said plaintiff in collusion and conspiracy with the said Tarangnath Mitra. Then, paragraph G at page 24, my lord, the defendant by letter dated such and such replied to the plaintiff stating that no amount was payable in the fabricated bills since payment of 33,904 had already been made in respect of the said genuine bills. The defendant enclosed a check of rupees 1,26,609 in full and final payment of all dues of the plaintiff. A copy of the defendant's letter dated such and such given. Then, my lord, in paragraph H also he is saying the same thing. It is apparent that in collusion conspiracy with each other, the said Tarangnath Mitra and the plaintiff have brought into existence the said fabricated bills and challans and or the other documents in respect to the same, and wrongful and illegal demands are being made. I'm just pointing out, Your Lordship, exactly the positive case made out by the defendant. These are the positive cases made out. But now, my lord, The alleged demand and claims have been made by the plaintiff in collusion and conspiracy with the with and at the behest, connivance and instigation of the said Tarunnath Mitra, who is attempting to harm the defendant for his ulterior motive and gains. No materials covered by any of the alleged purported invoices were ever received by the defendant. It is also apparent that all the aforesaid allegations, invoices, and corresponding delivery channels have been forged and fabricated to support the said purported claims and demands of which are specifically denied and disputed. Now, subsequently it transpired that that in an attempt to give a color of genuineness to the fictitious and fabricated bills, this is a very important paragraph. The said Tarunnath Mitra, in collusion and conspiracy with some suppliers, including the plaintiff, had included some of the said fabricated bills with the genuine bills at the time of obtaining VAT credit. Not pausing here for a moment, it has been explained later on, but VAT credit is when we are supplying, we are realizing tax from them on our supplies. Then when manufactured goods are being made and it is being sold or supplied, then again tax is to be realized. Then there is some adjustment between the payment they have already made at the time of purchase and also at the time of sale. This is the system. Now, he is pointing out that it is very important paragraph, Tarunnath Mitra, in collusion and conspiracy with some suppliers, including the plaintiff, had included some of the said fabricated bills with genuine bills at the time of obtaining VAT credit. Neither the defendant nor Subrata Datta was aware at the contemporaneous time that VAT credit may have been obtained by the said Tarunnath Mitra in respect of some of the fictitious and fabricated bills to suit his personal ulterior motive. After coming to know of the same, the defendant has refunded, repaid, and or reversed the excise department along with interest any credit that may have been obtained by the said Tarunnath Mitra in respect of any of the fictitious and fabricated bills. Well, this is very, very important.
They have not produced any document to show that.
No. Yes, Manoj. One document they have produced, that is that I pointed out on the previous day. That was a certificate given by their accountant.
That we have reversed.
Certificate given by the accountant,
their own accountant.
Have realized, and that accountant was not in the box. That has not been proved, though it has been marked exhibit. I will argue on that. Yes. Now, VAT credit may have been obtained by Tarunnath Mitra. The defendant has refunded, repaid, and or reversed to the excise department along with interest any credit that may have been obtained by the said Tarunnath Mitra in respect of any of the fictitious and fabricated bills. Accordingly, the defendant has not received any benefit of VAT in respect of the said fabricated bills, which are the subject matter of the present suit. A copy of the certificate issued by excise consultant, their consultant, of the defendant certifying the above is annexed hereto and marked annexure B. Now, my lord, subsequently, it is also transparent an attempt to give to color genuineness of the fictitious and fabricated bills. The said Tarunnath Mitra in collusion and conspiracy with some suppliers, including the plaintiff, had purportedly included some of the fabricated bills with the genuine bills in return and statement of records filed with the commercial tax department with ulterior motive. So, my lord, before taking adjustment, my lord, they are claiming adjustment of VAT which they have paid at the time of purchasing the raw materials. They are supplying the accounts before the excise department. These are the bills, and these are that paper I will show, my lord. And these are the VAT we have paid. That has been given, and now he is saying that to cover up that, but because he knows that those documents will be produced, because those documents were placed before the company code. Well, in the company code, the excise department was called upon to produce the papers. And a company code, they have produced the paper, the excise department. And it was directed by the Honorable Judge that the copies of those statements be my lord, supplied to the party. We have received a copy. And he is apprehending that those papers will be produced. That's why this statement has been made. Now, my lord, that subsequently transpired that an attempt to give a color of genuineness to the fictitious and fabricated bills, the said Tarunnath Mitra, in collusion and conspiracy with some suppliers, including the plaintiff, had purportedly included some of the said fabricated bills with genuine bills in the returns and statements or records filed with the commercial tax department with Alkira. Now, my lord, no reliance can be placed on those, etc. Now, my lord, in the last, however, in the last 3 lines, however, and in any event, to tax benefit has been received by the defendant in respect of the said fabricated bills because of the above, and the benefit, if any, has been returned or adjusted. This is very important. Returned or adjusted. It has not been proved. Now, look. Next page. It is evident that the plaintiff has been acting in collusion and conspiracy with the said Tarunnath Mitra to defraud the defendant and cause loss to prejudice it. Now, with reference to this is the case made out. Before dealing with the allegations made in the paragraph, he made out this case about this particular dispute. Now, the statements and denials in the written statement have been made paragraph wise, and that the sum, the sum and substance, that is the thing which I have read out. It is the sum and substance.
Right.
That Tarunnath Mitra, I'm just repeating, also can you excuse me, that director Tarunnath Mitra, in collusion with me and other suppliers, used to create fictitious bills along with genuine bills. And he was in the department of purchase, and he used to sign checks in his own by single signature, in his signature, and he created those bills. And before the tax authorities, statements have been filed, because he is already in the know of the matter, because the matters are produced before the company court, that those documents will come. Now, my lord,
and no proceeding has been initiated against Taruk by the matter any point of.
No, nothing.
That you have
that will show from the evidence.
You have argued on the last question. Yes.
I will read out the evidence of Subhuto Datta. And my lord, this the fictitious bills are, my lord, produced, and thereafter manufactured goods are produced and sold out of the materials, my lord, received from the fictitious bills, and those sent-back adjustment was claimed, and that is why, my lord, for the purpose of that, they have made created. Tarunnath Mitra created the statements and returns, etc., showing those fictitious bills as if they are genuine bills, and they have taken adjustment. Now he is saying, adding this, my lord, you will also kindly excuse me for repetition, that his defense is this, that those adjustments were claimed, no doubt, but later on those are returned.
Yes.
Because we have been able to make out that there was no such bills and no supplies, etc., etc. Now, my lord, for your lordship, my lord, for shortening the matter, you will also kindly come to page 253 of the part 2 in this connection. What was it? 253. 253. My lord, this is the
certificate of the accountant.
Certificate of the accountant, and my lord, a plain paper. Anyway, my lord, this was filed, and this accountant, Prasanto Sen, he was not in the box. This is the only proof of return of the, my lord, claims they want to rely upon. This is the only paper. Now, my lord, this is the case. This is the sum and substance of the defense case, my lord. Apart from, my lord,
Yes.
now, my lord, kindly see, my lord, next, he has dealt with the different paragraphs, and again, the same thing has been made out in page 35. Page 35 is reiterated these statements. Page 35, my lord, from 1, 2, 3, 4, fifth line from the top. The purported purchase statements and records, if any, of the commercial tax department referring to said fabricated bills are incorrect and have been brought into existence by the said Tarun Mitra in same statement in collusion with other suppliers, etc. And
yes,
it is repetition of the case he
Need
has
not- need not
already
please, yes.
stated. Since he was replying the matter with paragraph wise of the plaint,
yes, Mr.
that's
What-
why he has.
What next?
Next, my lord. Next verification. In the verification, he is saying, I, Subodho Dotto, son of late such and such, aged about 70 years, residing in such and such, solemnly state and declare that I am a director of the defendant above named, and I know and have made myself acquainted with the facts and circumstances of the suit, and that I am competent to sign and verify this written statement contained paragraph such. This is the verification. So I'm not going into the very details of the verifications. There are so many things to be argued, but I am not in a I'm not of such a lawyer to dispute with those matters. Now, your lordship kindly see. Yeah. Yeah. Then he was saying that he was a director, but he was not writing director of the company under his signature when he was signing the written statement. In the resolution, we find Millard, he was the vice president of the company. Maybe there may be elevation in the meantime. Now, Millard, again in affidavit, next page, he is saying, I am director of the defendant, and again in paragraph 2, I have been duly authorized. This is Millard misleading. I have been duly authorized by the defendant to sign, verify, etc. This authorization was not there in 2011. We are getting the authorization in 2015. Well, this is the written statement. And I'm just trying to shorten the matter in this way that the exact defense taken is that the allegation against Tarun Mitra and what he had done. And the statements made before the excise department and whether the adjustment were given back or not.
Yes.
That is the thing. This is the whole matter in this country. And the number one issue is this before your lordship now decide whether it is a registered company or not, a registered partnership or not. Now, on this point, I have already submitted to your lordship. One exhibit was there, and in order 21 Rule 97, we were giving the details after taking certified copy from there, from the record of the registrar, we have given for your consideration at the time of hearing. There, we get the name of the partner, their joining date, etc. All the details are there. which is necessary under Section 69 of the Partnership Act. And and it is also, well, in this point, in this juncture, I draw your lordship's kind attention that 69 requires registration of the partnership firm at the time of institution of the suit.
Yes.
At the time of institution of the suit, that must be registered. Like 36 notice before the judgment suit. No notice, no suit. Now, I'm going to the next. In the affidavit in chief, I am just not taking your lordship's time. The same statements are there. It is obvious,
Yes.
Same statements should be there, as it has been stated in the written statement. I will be going to the cross-examination state.
Yes.
Now, before going to cross-examination, I'm just showing your lordship, the some certain paragraphs. I will not read out. I'm just point it out, Your lordship kindly see page 56. In the chief, he is denying our statement in paragraph 25, 26, 27, 28, 29, 30, 31, 32, 33. Oh, sorry, I'm sorry, I'm sorry, Your lordship, excuse me. It is our chief. It is our chief. Well, our chief. Now, then I will go to the in our chief, relevant paragraphs. I'm just drawing your lordship kind attention. Chief of Manoj Kumar Jaiswal. I'm sorry, Is it Chief of Manoj Kumar Jaiswal? There, he has stated all these things and the documents. Page 47. Page 47, I say that pursuant to supplies made by the plaintiff with the company, various bills are raised upon the company to the sum of which 21,02,203. The dependent company has received the said bills without raising any objection and demur whatsoever. I am filing 14 number of bills, but bills numbers are given. Then the said bills are typed out at our office and signed by Sri Ajay Kumar Jaiswal, one of the partners of the plaintiff's firm. I know the signature of the said Ajay Kumar Jaiswal. I am filing 14 challans issued to Examine and Allied Private Limited by Trade Center being number such and such. Challan number given. The said challans were written and signed by Ajay Kumar Jaiswal, one of the partners of the plaintiff firm. I know the writing and signature of the said Ajay Kumar Jaiswal. These are the said 12 bills and challans may be marked Exhibit 2 series. Then, the original bills and challans having been received by the defendant, etc. Then demand notice and the demand notices, and then the certified copy of the order of the company code, Exhibit 2 at page 52. Then 12, page 53. I say that since plaintiff duly sold, supplied, and delivered the goods, and the same were received by the dependent company without any objection, and or given as to its quality and or quantity at any point of time, all these supplies affected by the petitioner are received by the defendant company without raising any objection. It will be evident from the purchase statement of the defendant company and the records submitted before the commercial tax department by the defendant company that were actually received by the defendant company and the said company had taken the tax benefits thereof. Then denials are there at page 56 onward, denials of the defense case. From paragraph 25 to 33. Starting with not a fact.
Yes.
Then, my lord, at page 60, my lord, we will be getting he has placed the affidavit in chief.
Yes.
Well, at this juncture, I am just seeking your lordship's kind leave to say something out of this case. Your lordship kindly see. After filing the affidavit in chief, thereafter it is being said that I have signed it, I have done it, etc., etc. These are, my lord, absolutely redundant. It has been said by the Honorable Supreme Court. In 2012, my lord, that this is not necessary because affidavit was done before a competent person. And he simply filing will do. The witness will come at the time of cross-examination only. Not before that. That is the case name I can remember, the Rosillal's case.
The documents are to be tendered and proved.
Documents are to be proved from the statement of the chief.
Oh.
It is signature. I know he signed in my presence. It was typed in my office. In this way, the required statement.
Affidavit will be sufficient.
Yes, and there is a judgment also of our court that those statements must be there in the chief. Otherwise, if further questions are being made, it amounts to recall.
But then how will an objection be made when it is tendered and exhibited?
Well, objection will be when the affidavit chief will be, my lord, dealt with by the learned court, my lord. Then from the statements, whether this ejectment notice was typed in my office as stated,
But
whether
the document is
and if there be any objection by the other side, he will
but that scope then goes if it is not tendered to the witness in front of the other side.
Yes, witness will produce the document and statements will be taken from the affidavit. Well, on the next,
so therefore, the document,
I'll bring the judgment.
The witness has to be confronted with the document, and there has to be a scope of the other
side. That is in cross-examination. That is in cross-examination.
No, when a document is marked as exhibit, admissibility has to be taken immediately.
Yes, admissibility in terms of Evidence Act.
Yes,
that has got to be gathered from the chief, whether he has stated or not.
Even if he states, there wouldn't be any scope of the other side taking an objection to that.
Yes, he will make objection as we do. I'm putting my lord as I'm raising my objection.
What is the opportunity?
Objection.
In
cross, he will cross him.
He will cross him, but the document has already been exhibited, marked as an exhibit. Then
no,
if it goes by the exhibit,
marking of exhibit. You also
for marking of exhibit, it has to be tendered.
Documents will be tendered, but statements will come from the affidavit. Again, statement from
the document is tendered to me. I am the witness. I'll keep mum and I'll say with my affidavit.
No, the judge will ask the lawyer in which paragraph you have stated. He will point out this is the paragraph with regard to this document.
And the witness will keep standing and smiling.
Yes, and witness will not say anything. Witness will face the cross-examination.
No, but if the very well. We want to. I don't know of that judgment.
Well, I'll produce that.
Please.
Next day, I'll bring that.
Next day, why? Oh, achha, next day.
Next day.
But we'll continue after recess with this.
Yeah, sure. I'll continue after.
remembers, I commented before Lordship that I'll start after this Saraswati Puja.
Yes, yes, very well. I hope, Mr. We hope, Mr. They does not take till Saraswati Puja for.
I'm sure you'll finish today.
Eh?
No.
No.
Mr. Banerjee is dictating when you will finish. No, Mr. We request you to be precise, but we have made the print of your submissions. Now just show the.
Well, I'm proceeding in a precise way.
Yes, yes, do that. Do
Your
it.
Lordship kindly see. I'm proceeding in a precise way. কি করেছে? এই তো প্রিন্টিং চিপে আছে। কি করে জানবো? আপনার রিসার্চ তো চালিয়ে এখন আপনাদের ক্রস আছে, ডকুমেন্টস গুলো
Item number 26 to continue.
Yes.
My lord, I was
PW1.
rather in the PW1 cross-examination.
Yes.
Now, my lord, kindly come to after the bills and receipts, my lord, kindly come to page 61.
61.
Examination chief, my lord, certain documents are marked.
Yes.
That is certified copy of the order of the Honorable High Court Exhibit 2. Then, my lord, one notice was given for production of documents.
What was this order? High Court order?
That is the, my lord, company court order.
Oh.
Certified copy of the company court order. Now, my lord, the notice to produce document, as we usually say, notice to produce document, Exhibit 3. And challans, 14 number of challans, Exhibit 4. And demand notice, Exhibit 5. Then, my lord, cross examination starts, page 60. Bills and challans. Now, my lord, one the status of the partnership, whether it is registered or not, whether this point has been taken in the written statement or not, it is a point of law. And regarding the eligibility of the plaintiff to institute a suit, it touches a very, very crucial point of law. That is that can be gone into whether there is pleading or not. So, my lord, cross-examination is there. I did not file the partnership deed due the learned court. Plaintiff firm is a registered partnership firm. Accounts of the plaintiff's firm is regularly audited. In cross-examination, first line. One Messrs. Gupta Anil Kumar and brothers is the auditor of the partnership firm. I became a partner of the plaintiff firm in India 1984. At present, my age 50 years. Then, my lord, next on the bottom, further continuation, 12th of March 2013. Not a fact that the plaintiff firm, namely Messrs. State Center, is an unregistered firm. A suggestion given. Then, my lord, myself filed application for winding up before the Honorable High Court at Calcutta. It is a fact the Honorable High Court has been pleased to relegate my claims into a suit. Honorable Mr. Justice Sanjeev Banerjee passed this order. I have been duly authorized by other partners of the firm to adduce evidence in this case. Then says, I did not file any such document before the learned court. It is a fact that I alone is acquainted with the facts and circumstances of the case. Ajay Kumar Jaiswal will not depose in this case. Ajay Kumar Jaiswal is my cousin brother. I have 4 cousin brothers. Sanjay Kumar Jaiswal, his own brother. I have 4 cousin. Sanjay Kumar Jaiswal, the own brother of Ajay Kumar Jaiswal. Sanjay Kumar Jaiswal has his own independent business. I did not file any document or copy thereof along with the plaint. Then, my lord, further consideration, I am ready to file trade license. After that period, 2011, 2012, it is a fact that that we made applications for winding up before the Honorable Court, not against the dependent company. I did not file any document of purchase orders on diverse dates, as stated in paragraph 4 by my affidavit in evidence. Volunteers that those are verbal orders. It is a fact that the dependent company is amalgamated with Exumate and Allied Products Limited. We used to have business transaction talks with Taragunath Mitro, Mukul Rai, Subroto Dotto, and Jawahar Mukherjee.
So there are no purchase orders on record.
No, all verbal. No written order. Nobody has produced any written order. We have not produced, they have not also produced regarding past transactions. That, though it will appear from the evidence that this business transaction is going on for a long time. We used to have business transaction talks with Taragunath Mitro, Mukul Rai, Subroto Dotto, and Jawahar Mukherjee. This is very important, Miller. In cross-examination, it is coming out. We used to give orders only verbally for several lakhs of the dependent company. Order was given for rupees 21 lakh 2,203 verbally to the dependent company as stated in paragraph 5 in affidavit in chief. Challan by handwritten carbon copy and bills of typing was made in this regard. We are in the business with Exomate and Allied Products Limited, must be since 1985-86. I cannot say now whether I shall adduce further evidence in my support. Said Exomate company placed orders on our farm. We supplied goods in 2006, 2007, and 2008. We had supplied goods prior to 2006 to 26 09 2009 06 2009 to them. All the bills are sent to Exomate company as above. As at that very time, Tarunath Mitra was working with the said Exomate company. Other 3 persons were also working. I did not file an order passed by the Honorable Justice Maharaj Sinha. That was the order regarding amalgamation of the companies. I did not file any document to show that I have given authority to depose the plaintiff firm. Myself and Mr. Ajay Kumar Joyswal are 2 partners of the plaintiff firm. Then, my lord, suggestion given, not a fact that Mr. Subroto Dotto of said Exomate company was supervising in manufacturing activities of the company. Mr. Tarunath Mitra was the director of the Exomate and Allied Products Private Limited. He used to look after all the jobs, including account work. I do not know as to who in particular used to do the jobs of accounts therein. It is a fact that at present Tarunath Mitra has got no concern into the dependent company. Then, my lord, very important further consideration at the bottom. Dependent company of Exomate and Allied Products Private Limited company did not place any written order before us. We do not manufacture anything. We purchase materials from other stockists and supplied on its commission. Not a fact that the most of the bills and challans are signed by Tarunath Mitra on behalf of the dependent company. This is very important, Milord, that to be looked into from the documents itself. Not a fact that we did not supply the materials as per bills and challans produced in this case. The challans which are filed in this case on our behalf are road challans. Exhibit 4 collectively is shown to the witness on dock. Bills are raised by plaintiff company at the address of B.B. Ganguly Street and the materials are supplied at the factory address. So, my lord, Exhibit 4 or mark exhibit at the instance of the plaintiff and it was cross-examined also. So, we cannot raise any objection as to the Exhibit 4. Now, my lord, further cross-examination PW1, or whether it is false or genuine, that's a different matter. Further cross-examination of PW1 is resumed today. It is necessary, Mr. Ajay Kumar Joyswal will depose in this suit, if necessary. I have not submitted before this court to show that our firm is a registered one. I do not know about the Partnership Act 1932. I saw the order on the basis of which there was amalgamation. I have submitted the authenticated copy amounting rupees 21 lakh 2,223. I read the written statement of the suit. Before filing this instant suit, we have filed an application before the Honorable High Court. The defendant company disputed the bills. We received the same of rupees 1,26,609. Without going through the documents, I am not in a position to say as to whether we made any connection after getting 16,609. It is a fact that the entire claim of the plaintiff in terms of the order of the Honorable Justice S. Banerjee has been relegated to suit. Presently, there is no petition before the Honorable High Court in connection with any matter. Not a fact that the defendant did not accept goods without objection.
Double negative. That means they did accept with objection.
Suggestion is being given as if they have received after giving objection. That no such case is made out in the written statement. Anyway, not a fact that we did not supply goods as per purchase statement. My lord, purchase statements is the documents, my lord, submitted before the tax authorities. Now, my lord, further cross-examination. I have not filed any document to show that I am a partner of the business, not a fact that I am not entitled to claim in the amount as paid for. I have already filed documents for which notice was issued to me. I have not supplied anything to Tarunnath Mitra, not a fact that I have filed documents in collusion with Tarunnath Mitra for illegal gain. Then with another witness, that is the Ajay Kumar Joshua.
Cousin.
Cousin. Also a partner.
His partner, obviously.
No, his my lord, his evidence, I think, my lord, in my reading, my lord, I don't find any importance to it. Not so much relevant. Anyway, I'm just, my lord, kindly come to page 74. Paragraph 10.
Yes.
That to prove genuineness of the aforesaid claim made by us with regard to supply of materials to the transferor, a company, a subpoena issued at the instance of the learned advocates on record on the plaintiff to the Commissioner of Commercial Taxes, having the office at 14. In this suit, my lord, the Commissioner of Taxes was summoned for production of the documents. But we will find that the documents are not produced. They said there is a legal bar. But before the company court, they have produced all the original documents. And copies thereof has been, my lord, given to both the parties. And that was considered by, my lord, Justice Sanjeev Banerjee. That exhibit 2, I will be placing once again, my lord, relevant portion. Now, my lord. A subpoena issued at the instance of the landed advocates on record of the plaintiff to the Commissioner of Commercial Taxes, having its office at 14 Beliaghat Road, Calcutta 15, to produce the VAT returns for the financial year 2005-2007, as well as the record of the in, out and output for the financial year 2005-2007 in respect of Messrs. Exomate and Allied Products Private Limited of 4 Ribbon Street, Calcutta 16, being VAT number such and such, and SCC number such and such, and to depose and submit the following documents on behalf of the plaintiff, Mr. State Center, before the Honorable High Court at Calcutta, pursuant to the subpoena of the above referred to documents, the purchase register for the year 2005 to 2006 and 2006 to 2007 were produced and submitted before the Honorable High Court at Calcutta by the State Department of Commercial Taxes. His Lordship, the Honorable Justice Maharaj Sinha, as His Lordship was by an order dated 18/6/2000, was pleased to direct the photocopy of the above mentioned purchase registers may be supplied to the plaintiff therein. This is the signed copy issued by the Assistant Registrar, Original Site, High Court, Calcutta on June 24, 2009, and server copy from the official website of the Honorable High Court at Calcutta of the said order dated 18/6/2009, passed by His Lordship, the Honorable Justice Maharaj Sinha, as His Lordship.
What was this order, Justice Sinha's order?
My lord,
that amalgamation.
No, it was the company court order. It was passed by the company court also. At that point, on that day when the order was passed, Justice Sinha was there. Justice Banerjee was not. I say that accordingly, bunch photocopies of documents consisting of several order sheets received from Form 14 of the West Bengal Value Added Tax 2005 from Form 1 under Central State Tax Act 1956, several notices, purchase statements, and purchase register for the period 2005 to 2007 of the Exomate and Allied Products Private Limited, auditor's report of the Exomate and Allied Products Private Limited, etc., was handed over to me by our advocate on record, and out of the said document, I am relying on the following documents, that is the purchase statements and purchase register for the period 2005-2007 of the Exomate and Allied Products Private Limited. I say that the said company, petition number 57 of 2000 by an order dated April 13, Honorable Justice Sanjeev, that was the order of relegation. Then, my lord, paragraph 13. I say that a notice to produce document has been issued by my learned advocate for production of VAT returns for the financial year 2005-2007, as well as the record of the input and output for the financial year 2005-2007 in respect of Messrs. Exumate Allied Products Private Limited of 4 Ripon Street, Kolkata 16, being VAT number such and such, SEC number such and such. But till date, the same has not been produced in spite of their assurance to produce the same. That since the said VAT returns for the financial year 2005-2007 as well as the record of input and output for the financial year 2005-2007 are in respect of Messrs. Exumate and Allied Products Private Limited of 4 Ripon Street, Calcutta 16, being VAT number such and such, SEC number such and such. That is the company before the merger of the present dependent company. Plenty praise for leave to file the photocopies of the same for proper adjudication of the instant suit. The copy of the said notice dated 2011-2014 is filed in the learned court, which has been received by the learned advocate of the defendant by putting his signature on the same. The said notice was written by my learned advocate and signed by him in my presence. I know his signature, the signature of the learned advocate of the defendant and my learned advocate, which is appearing in the said copy of the notice. This is the said notice to bodies document issued by learned advocate for production of the VAT returns for the financial year 2005-2007, as well as the record of the input and output of the financial year 2005-2007, mentioned in the purchase statement and purchase register for the period 2005-2007 in respect of Messrs. Exumate and Allied Products Private Limited of 4 Ripon Street, Calcutta 16, being VAT number such and such, SEC number such and such, and the same may be marked as exhibit. When the necessary ingredients have been given, marking will be done by the learned court. Then, my lord, that since the notice said VAT returns of the financial year 2005-2007 as well as the record of the input and output for the financial year 2005-2007 mentioned in the purchase statements and purchase register for the period 2005-2007 in respect of Messrs. Exumate and Allied Products Private Limited of 4 Ripon Street, Calcutta 16, being VAT number such and such, SEC number such and such, are not produced till date, and which is in the custody and control of the dependent company. Thus, the photocopies of the same may be accepted as secondary evidence for the proper adjudication of the instance. There is no statement made as true to my mind. Then, Miller. PW2, Miller cross-examination at page 81. This is the original copy of the notice to produce document, and the same is marked Exhibit 6. There are 17 numbers of Xerox copies being page number 16 to 33. These copies are being handed over to us by the direction of the Honorable High Court. I have submitted the said copies before the court being pages 16 to 33, and the same is marked Exhibit 7 series after objection.
But where does the cross-examination start? Because next page says further cross-examination.
Oh, I see. Sorry, madam.
Probably that should be
earlier.
That further should not be there.
Should be earlier.
Because page 81, further examination in chief is going on.
Yes, further examination in chief.
So this further in page 82 must be wrong.
80, 81,
Or
82. Yes, there is continuation of the cross-examination.
no, where is the continuance? It's never started before.
Yes, yes. I understand. You're also trying to find out the starting point. Dr. Division,
Is something missing?
Oh. Oh. That was closed on 5th November.
That further in the cross-examination is wrong. Probably.
Yes, that will be starting point of cross-examination. Then further is there, Exhibit 7 series, next page. Further cross-examination PW2 started on 16th July 2015. I have submitted document to show that I am partner of Trade Center. At this moment, I cannot remember what type of document I have filed. At this moment, I cannot say whether I have submitted any document to show that I am the partner or not. I cannot remember at this moment as to whether I have submitted any authorized letter to depose in this suit or not. I have submitted the partnership deed of the Trade Center. Trade Center is registered under Modi House. This is important. It is not Modi house, you know. That you know, number
Todi Mansion.
Todi house.
Todi Mansion.
Todi Mansion.
Freudian slip.
Todi Mansion. Just opposite to my Lord Govindo, that is কি বলে ওটা? এইটা ওই বড় বিল্ডিংটা বলো না।
Thank God this has not become the World Trade Center.
Yes. Poddar Court. Opposite to Poddar Court. That's a very tall building. In the 10th floor office was there.
Nowadays is not no more.
No. Now it has been shifted. In our early days, I used to visit there. In 70s, my lord. In 70s.
You had something there.
Yes, I used to visit there for having copies, etc.
Acha.
And also for registration of farms.
Oh, acha.
From registration of farms, registration of societies. So that is the only place there.
Still, it is the only place.
এখন চলে গেছে
Office is the same.
There was no agreement with dependent number Mageba. I was not present at the time of amalgamation of company. That is to say, Mageba, we do not manufacture MS angles, MS channels, MS flats, or RS joist. At the time of delivery, I was present at 76 Rammohan Rai Saroni. I know. Well, this is very important. Well, these are coming out in cost examination.
No, we do not manufacture MS angles, but did you raise bills for this? Then this goes against you.
We used to purchase from the market.
Did not manufacture.
We did not. And
manufacture is a keyword. Yes, you said that previously also. Purchase and supply.
Yes, manufacturing. That is for, as I remember, subject to correction by my learned friend, that for construction of bridges, the dependent company used to purchase all these materials.
Yes.
তাই না বীজ তৈরি করতো না Mageba bridge production. We do not manufacture MS angles, MS channels, MS flats, and RS joints. At the time of delivery, I was present at 76 Rammohan Rai Saroni. I know 76 Rammohan Saroni. It takes at least 5 to 6 minutes to go to Amma Street PS from 76 Rammohan Saroni. I cannot remember as to whether I have issued a bill in Mageba Products Limited or not. Our office is situated at 76 Rammohan Rai Saroni. The office of Mageba Bridge Products Private Limited is situated at 4 Ripon Street. I know 232 Bowbaja Street, where the bank is situated. The defendant issued a check of rupees 1,26,609. I have filed bill and challenge which show the amount due to us. I will ask my learned advocate as to whether the evidence of Commissioner of Commercial Tax is necessary or not, and thereafter I will take decision. It is a fact that the dependent company has deposited the sum of rupees 12 lakhs 38,000. That is in view of the order of the company code, deposited with the register original side.
That is still there.
Yes, still there. To the registrar of Calcutta High Court, not a fact that our claim is illegal.
That was made subject to the outcome of this litigation.
Exactly.
Well, it was an order in the winding up proceeding.
Yes.
Yes, in the winding up proceeding, but was it because they were relegated to a suit?
Yes.
So whether that was
In trial court's order, that learned court below was pleased to.
We'll get it in exhibit 2, my lord. We'll get it in exhibit. We'll get
pleased to dismiss the suit and say that the amount can be withdrawn. But there is a stay of the decision.
Stay is there from this order.
Right.
Now, my lord, not a fact that the bills and challans we have submitted have been prepared according to our own interest. We did not prepare the bills and challans after asking defendant. We have our VAT registration number such and such. I know the VAT number of the dependent company. We do not have document besides the documents in addition to the documents we have submitted before this court. Not a fact that our entire claim is nullified. A few lines from the cost examination are very important regarding the supply of the goods, etc., etc. These are coming out in cost exam. So it will go to the benefit of the plaintiff. They have taken out these answers. Now, my lord, we are going to defendant Subrata Datta. This is very, very important. Now, my lord, this is affidavit in chief. He says, I am the vice, page 85. I am the vice chairman of the dependent company, and as such, I am principal officer thereof. I have made myself acquainted with the facts and circumstances of the instant case, and I have been authorized looking after the matter on behalf of the company. I am competent to affirm this affidavit. 2. I further submit. Well, I join issue here. I further submit. Submit cannot be an affidavit. A submission cannot be affidavit. That may be argument.
Yes.
Then, I am duly authorized by the defendant company to sign, verify, affirm, make instant affidavit on behalf.
So he was not sure, probably. That's why he submitted.
Yes.
That's why it's not a statement. So because this client wasn't sure.
We cannot take
So
it
he
for
was submit.
his knowledge. We cannot take it as it comes out from an
So
affidavit.
here your point comes in that the resolution was dated 2015.
Yes, here.
So that point,
Yes.
very well.
Yes, fine. That's why we have got some sort of paper.
Yes.
Now we are competent to etc. Next third paragraph. I state that the written statement had been drafted on my instruction and has been affirmed and verified by me. This is very important. The contents of the written statement are true and correct. I state that the plaintiff has no cause of action against the defendant and the same should be dismissed. I further submit again, my lord, I submit. There has been gross suppression of and distortion of material facts for the reasons unknown. I respectfully further submit. But this is a peculiar affidavit in chief. Further submit.
He was very submissive.
Very submissive. Then, my lord, I respectfully further submit that this learned court assumes no jurisdiction to try and determine the instant suit. I submit again.
All the rest of the paragraph submit.
Plaintiff was, my lord,
yes.
Though submit, some facts are coming here. I submit that the plaintiff was a supplier of MS plate, etc. to Exhumed and Allied Products Private Limited, which has otherwise merged and or amalgamated with the defendant company in terms of an order passed by the Honorable High Court at Calcutta, sanctioning the scheme of amalgamation, etc. All references to defendant company would mean to include the Exhumed and Allied Products Private Limited in respect of the matters part to yesterday. So, my lord, one line we are getting from his submission that the plaintiff was a supplier of MS plates. Now, my lord, paragraph 6. I submit again that the suppliers are made by the plaintiff company as against the order placed by the defendant company from time to time. I don't know what you want to say. This is very, my lord.
No, but they say this is not contradictory to the stand. They say that some of your bills are genuine. So they admit that they were business transactions.
Supplier, not that only this transaction.
And they admit some of the bills, 3 of the bills. They say those were genuine, but so they don't deny that there was transaction.
Now, it is further submitted that I am otherwise looking after and do not supervision and execution in respect of the manufacturing activities and works relating thereto, and one Tarugnath Mitra, who was then a director of the dependent company, used to look after, supervise the accounts, finance, and purchase of the dependent company, including sanctioning of bills and supplies with the authority to singly sign the checks on behalf of the dependent company. Tarugnath Mitra was the sole signatory of the checks issued by the dependent company. Primarily, we had no reason otherwise to suspect his credibility, but the situation subsequently proved to be absolutely against the actual state of affairs, and the said Tarugnath Mitra has been in collusion and conspiracy with the plaintiff as well as certain other suppliers, has been responsible for siphoning away the funds of the dependent company by making payments against fabricated, forged and fictitious bills, which have been purportedly raised on the basis of fictitious and fabricated challans of such suppliers, showing purported delivery of purported materials without such materials being otherwise actually ordered by or delivered to the dependent company. Such siphoned monies were evidently being shared by Tarugnath Mitra with concerned suppliers. Then I state that he said Tarugnath Mitra, in order to siphon away money, aiding and obtaining with the plaintiff, had allowed fictitious bills and paid money without such supplies having been actually made to the defendant in respect to the same. It also transpired that forged and fabricated documents are manufactured by the said Tarunnath Mitra in collusion and conspiracy with such suppliers relating to such fictitious bills, and the said Tarunnath Mitra would sanction and make payment to such suppliers both in respect of genuine bills as also in respect of fabricated bills. I would respectfully submit that such checks were signed only by Tarunnath Mitra.
Mr. Dev, we would also be expecting from you arguments on the liability of a principal if the agent was authorized at the relevant point of time. Though subsequently allegations are leveled against him. Because Taruk was acting as their agent. So we would be expecting arguments from you on that. Because if the principal was liable and they admit that Taruk had the authority at that point of time. He was an authorized agent. So that aspect also has to be dealt with by you, and obviously Mr. Mukherjee will have to answer that.
Now, my lord, I would respectfully submit that such checks were signed by Tarunnath Mitra. The plaintiff taking advantage of said situation and in fact buying out this said Tarunnath Mitra has caused serious loss and damage to the business of the defendant company. This is very important, my lord. And neither the company nor the directors of the company were aware of such siphoning of the funds. I state that Tarunnath Mitra was otherwise dispensed with his service and transferred his share in favor of myself and my wife, Srimati Malaya Dotto, and resigned as a director effective July 2007. The same was intimated to the concerned banks immediately, with whom the dependent company are maintaining their account. Suddenly, in June 2008, a letter was received, that is the notice of demand. Then, my lord, details of the bills are there.
Yes.
Now, my lord, paragraph 11, my lord, details of the bills are given.
Yes.
Next, my lord, next page. The said bills were never received by the dependent company, nor the dependent company had knowledge of the said bills. The residual bills amounting rupees 19,75,594 are fictitious bills which have been stated in paragraph 7D, page 4 and 5 of the written statement. The said fabricated bills were issued during January 2006 to August 2007, and the demand for the same came 1 year later in 2008. It is submitted that no orders were ever placed by the defendant with the plaintiff in respect of goods purportedly stated to have been delivered to the defendant by the plaintiff under the said fabricated bill. It is submission. It is not his my lord, statement on affidavit. Then, my lord, actually, no supplies were made by the plaintiff to the defendant, and no goods were never ever received or consumed by the defendant in respect of the said fabricated and forged bills. The purported signature on the said fabricated and forged bills and delivery challans are not of any authorized personnel of the defendant company. The said purported signature have been evidently forged and fabricated by the plaintiff through its officers in collusion and conspiracy with the said Tarunnath Mitra. Now, my lord, here the bills have been referred to, but not individually. As a whole, it has been seen. Now, my lord.
Yes.
Then paragraph 12. The defendant company by a letter dated 1st August 2008 replied to the plaintiff stating inter alia that no amount is due and payable in respect of the forged and fabricated and or manufactured bills. And since 33,904 with regard to genuine bills number such and such, except for a sum of rupees 1,26,609, which was in respect of specifically to bill number such and not any other bills. A check of rupees 1,26,609 was otherwise issued, stating to be in full and final payment in respect of the alleged dues of the plaintiff. I submit that the said payment was in full and final payment of all the dues of the plaintiff. Well, Lord, this is also submission. This is the copy of the said letter dated 1st August 2008, the original of the said letter is lying with the plaintiff. The said letter was prepared as per my instruction, and I am fully aware and acquainted in respect of the signature made therein. The said documents are marked exhibit. I submit on behalf of the defendant company that purported claim of the plaintiff in respect to said fabricated bills are not payable and have been denied and disputed by the defendant company. This statement has got no value as regards evidence. It's submission. Again, I submit that curiously enough, in collusion with the same statements are coming out. Then we are next page. The alleged demands and claims have been claimed by the plaintiff in collusion and conspiracy with the personnel of the plaintiff and the said Tarunnath Mitra. It is most unfortunate that Tarunnath Mitra, who happened to be director of the defendant company, was attempting to harm the defendant company to otherwise fan his ulterior motives and gains. I reiterate that the materials covered by the alleged purported invoices were never received by the defendant company. It is also apparent that the aforesaid alleged invoices and corresponding delivery challenge have been forged and fabricated to support the purported claim of the plaintiff, which is equally denied by the defendant. It is also followed by a submission. Then, my lord, paragraph 15. Subsequently, it has transpired, but it is very important. Subsequently, it has transpired that an attempt to give color to genuineness of the fictitious, fabricated, and manufactured bills. The said Tarunnath Mitra being in collusion with plaintiff and have included some of the said fabricated bills with the genuine documents at the time of obtaining SENVAT credit. Neither the defendant nor me was aware of the contemporaneous time as to when the SENVAT credit may have been obtained by the Tarunnath Mitra in respect of the said fictitious and fabricated bills to suit his ulterior motive and personal benefits. Then again, paragraph 16, submission. On behalf of the defendant, neither the defendant nor me was aware of the contemporaneous time the SENVAT credit may have been obtained by the said Tarunnath Mitra in respect of some fictitious and fabricated bills to suit his personal ulterior motives. After coming to know of the same, the defendant has refunded. My lord, this is very important. Though it is submission, my lord, then, my lord, after coming to know of the same, the defendant has refunded, repaid, and reversed to the excise department along with interest any credit that may have been obtained by the said Tarunnath Mitra in respect of any of the fictitious fabricated bills. This is very, very, very important for the suit, my lord. Because had there been any such mistaken or any deliberate, my lord, fabricated bills are shown to the excise department,
yes,
and SENVAT has been claimed, then he is saying that after discovery of that, they have already returned the, my lord, benefit taken. Accordingly, the defendant has not received any benefit of SENVAT in respect of the said fabricated bills, which are the subject matter of the present suit. This is the certificate issued by, here it is coming. This is the certificate issued by the excise consultant of the defendant company, certifying the above. The same has been received by the defendant company in usual course of business transactions and need be marked as exhibit. As I was submitting, my lord, at the relevant facts must be there for marking a document in his chief also. That here, my lord, he has received from the consultant and it may be marked. His own consultant. The consultant is not coming to the box. Later on, it also transpired that attempt has been made in respect of alleged supplies fabricated bills with commercial tax department. I or none of the personnel of the defendant company was aware of the above about the said contemporaneous time. However, in any event, no tax benefit has been received by the defendant company in respect of the said fabricated bills because of the above benefit, if any, has been returned and or adjusted. Returned again, my lord, and or adjusted. He is not sure.
Yes.
Then my lord 18. In respect, I repeat and reiterate the statements made in here and above and deny, dispute the allegation, etc. My lord, that is repetition. Then, my lord, again it is reiterated, paragraph 19. Then, my lord, paragraph 20, is general denial, untrue and incorrect. Then 21, 22, 23, 24, 25, 26, all are submissions. All are submission. And it has been stated in the bottom, those are true to my knowledge. My lord, kindly see page 97. This jurat has been drafted, my lord, without applying mind. It is very much telling me, my lord. In this way, my lord, we should not mislead the court, my lord. Court is to rely upon us that we are saying the correct thing, correct law, and formulating the cases according to law. So, my lord, these are all submissions, my lord. So, in my submissions, we need not take it as affidavit in chief. Though no fact is coming out from all these submissions. No new fact is coming out. Exactly same thing or same denials are there. Now, my lord, kindly come to very interesting part of this case. That is a cross-examination of two persons.
Yes.
At page 99, my lord. It is very unfortunate, my lord. Your lordship has seen, he has simply produced the papers of that my lord, consultant, and now how it has been marked exhibit, page 99. But the authorization letter, exhibit A, I am not going to dispute it. Next, my lord, page 100. The letter dated 1st August 2008 and 19th November 2000 is handed over to the witness. The formal proof of the same is dispensed with and the same has been marked exhibit B and C. I am not on that. Then, my lord, this is the certificate issued by excise consultant of defendant company and the same is marked exhibit D with objection. My lord, mere marking a document as an exhibit will not do. My lord, the Supreme Court is saying repeatedly that exhibit marking is given only to identify document by the court and the learned advocates at the time of argument. Mere marking exhibit will not give any, my lord, credence for evidence. So, this exhibit marking is absolutely illegal. The marking should be done by the person who has created the document. He is the, my lord, primary witness. He is the best witness. Law of evidence says, my lord, only the best witness will come to the court. So, my lord, this exhibit D has got no value at all. And I'll be praying to your lordship that this exhibit D will not be looked into or to be considered at all as part of the record. Now, my lord, let us proceed to cross-examination. Then, my cross-examination starts. Presently, we use computer for generated work of our company. Presently, we also file company returns through e-filing. The resolution of the board of directors is also placed in the computer. The content of the exhibit A is also placed in the computer. We have a qualified person to look after our computer. This is very important line in view of section 65B of the Evidence Act. This line is very, that is the only fit person, 65B4, as I remember, to prove any document. Then my lord voluntarily says, sometimes you also board meetings via video conference, which our director of Switzerland. At this moment, I cannot remember whether I was instructed by my company in connection with the preparation of the written statement in writing. In the written statement, I signed, well, here, well, I have drawn the attention of the witness. In the written statement, I signed on each page of the same, but there is no mention of any credential under my signature. In the written statement, I have not used the seal of my company. Not a fact that the statement in the written statement are my personal opinion. Then, my lord, affidavit in chief is handed over to the to the witness on behalf of the defendant. There was a partition prior to the amalgamation of the company, and at the relevant time, I had no knowledge regarding accounts, etc. After amalgamation, I have become acquainted relying on the document which have been filed before this court. In this affidavit, I did not use any company seal, but I signed thereon. The incident on the basis of which the case has been arisen was occurred prior to the partition. I do not have any knowledge or accounts for those periods. The contents of paragraph 6 of my affidavit in chief are true to my knowledge. The system of working of the company has been mentioned in paragraph 7 of the affidavit in chief. And was prior to
The transactions in questions weren't before the amalgamation.
before the amalgamation.
But he says that.
He came to know after the amalgamation.
Yes.
He's saying from the records. I think
Yes.
from the record.
Must be.
In manufacturing activities, they are required supply of raw materials. And Mr. Tarunat Mitra used to purchase raw materials, and finished products were used to be sold in the market. This is very important consequence, giving the entire picture by a competent person. The plaintiff company is one of the many suppliers.
Yes, Mr.
The plaintiff company used to supply raw materials. There should have been an account relating to raw materials coming to factory or going out as finished products in the market. The company also maintain all kinds of accounts, and the same is a process. Then, Miller, this is very important line. I do not have any personal knowledge regarding the incoming and outgoing of materials. I did not see any books of account. But he knows nothing. Then, Miller, again, exhibit A, B, C, and D have been handed over to the hand of the witness. In those 4 exhibits, it will not reveal any allegation which have been made. Miller, next sentence. I do not have any knowledge of any transaction which was made by Tarak Babu regarding supply of goods, purchase of materials, issuance of checks. So many serious allegations are being made against Tarak Mitra. There might have been criminal prosecutions also on the allegation on the case made out by the defendant company. But he knows nothing. He says, Miller, I do not have any knowledge of any transaction which was made by Tarak Babu regarding supply of goods, purchase of materials, issuance of checks. So, Miller, the entire case of the defendant has not been. This is the person who knows nothing.
There is no other witness apart from Tarak Mitra.
Oh, Tarak Mitra was there.
Yes, apart from Tarak Mitra.
No. Then, I am not in a position to produce any books of accounts which was before partition. Then, the company as well as the directors did not know about siphoning of the company occurred during those periods. Not a fact that the forged and fabricated documents were not manufactured by the said Tarak Mitra in collusion and conspiracy with such suppliers relating to some. This is my suggestion. The incident as mentioned in affidavit in chief was transpired after amalgamation of the company. At the time, we did not make any complaint before the police authority. Till today, we have not lost any complaint regarding the fourth and fifth generator. My lord, kindly see the conduct of the dependent company and its director. Then at present, I am not in a position to say whether I charge Tarunnath Mitra for allegation or not, but I will have to see the same. At the time of occurrence of the incident or soon thereafter, no action was taken. It is a fact that after getting demand of the plaintiff, we mentioned the allegations which are available in 4 exhibits. Not a fact that the allegations which were raised in exhibit B and C are our afterthought. It was our suggestion. Then, my lord, there was no attempt to remove Tarunnath Mitra from his directorship. Again, my lord, we did not claim any amount from Tarunnath Mitra who made siphoning of the amount during the course of business. There was no adjustment of the alleged siphoning which Tarunnath Mitra surrendered his all accounts with the government. So, my lord, we are not getting any amount which was siphoned by Tarunnath Mitra. Simple allegations, he has siphoned money. How much? And from the books of accounts also we are not getting, no action taken. And my lord, rather certain transactions regarding his surrender, etc., transfer of his shares, etc., were taken place. Yes. And he was left scot-free. Then, my lord, here comes the settlement portion. Next. At the time of partition, Tarunnath Mitra left the company by giving share to my wife and myself. At the time when Tarunnath Mitra left as per agreement, all accounts were updated and cleared. So Tarunnath Mitra was not was scot free. Then, my lord, an application for winding up of the company was moved before the Honorable High Court, and the Honorable High Court passed on judgment Exhibit 2, and I am satisfied with the judgment. So, my lord, if he is satisfied with the judgment, he is also satisfied with the reasoning given by his lordship. I refer to from the Exhibit 2. Then, my lord, Exhibit 2 is handed over to the hand of the witness. I signed in the purchase register for the period 2006 and 2007. My lord, kindly see. Earlier he said, I know nothing. But I signed in the purchase register for the period 2006 and 2007. Not a fact that I know about accounting. Voluntarily says, I used to sign on the statement on good faith in my written statement. In my written statement, I did not mention that. I used to sign on account on good faith, and in my affidavit in chief, I did not mention the same. Then, my lord, this is a very, my lord, legally accepted principle he has said. When the account is signed by the director, it is presumed that the account is correct. This is, my lord, legal presumptions. When I sign any document, then I have read it, I have understood. Not a fact that not a fact that had account books been produced before this court, the claim of the defendant would have to be genuine. That is my suggestion. That's why it has been, my lord, not produced. I am trying to establish a, my lord, presumption for non-production of the account. Then, my lord, if anyone make payment of tax to sales tax authority, receipt can be available from that authority, and in case of refund, receipt is also available. But I was trying to take the real transactions with the taxing authorities. When the tax is paid, receipt is granted by the taxing authorities. When it is refunded, then also receipt is given for refund. So we are not getting those refund receipts, not on the record.
Yes.
In case of any payment of VAT at the time of purchasing the raw materials, the same amount of tax can be adjusted at the time of selling finished product, as I was saying. Lord. Please explain it. I have taken it from his mouth. What is the procedure? Then, my lord, at the time of supplying the raw materials by the dependent, VAT was paid by the same was adjusted at the time of selling of finished products. Voluntarily says, we return the said amount of tax for adjustment. The amount was adjusted and we receive adjustment amount and we have receipt for the same. Well, this is very important. We have receipt for the same. We have not filed any pay receipt. Then, my lord, we made the application before the sale tax authority for return of the excess amount. There was hearing, there was an order of the hearing, but I have not submitted any document in that respect. We have not filed any accounts from where the said amount of payment of adjustment can be found. My lord, can you see? Then, my lord, I suggested not a fact that the refund amount is a manufacturer's story. At this moment, I cannot say, but after going through the records, I will say about the filing of return after 2010. It transpires from the account that there was document which were forged and manufactured by Tarunad Mitra. Where are the accounts? Accounts are not filed. Then, my lord, I have not filed accounts before this court presently. I have taken it, my lord, very candidly. He has said I have not filed any. We have not filed any criminal case against Tarunad Mitra for forgery. Not a fact that the statement which made in paragraph 9 of my affidavit in chief are manufactured. Not a fact that the allegations which I made in paragraph 9 of my affidavit in chief have no basis at all. Not a fact that the bills which have been mentioned in paragraph 11 of my affidavit in chief have no basis at all. I was not aware about the transaction which was made during those period 2007. Well, he knows nothing. And he has said it, he has confessed it in cross-examination. And my lord, not a fact that the claim of the plaintiff is genuine one. Not a fact that I do not have any personal knowledge regarding the accounts of sale tax matters and Senvat matter, Senvat, not a fact that I depose falsely. This is the, my lord, defense case and the connected witness, rather sole important witness. And my lord, we have to keep in mind that, my lord, the transactions are fabricated, false, and that was done with the connivance of Tarunad Mitra and my client. These are the allegations. These are to be proved. That was the intention expressed by my lord Sanjeev Banerjee in his company matter. And that has to be proved here. That is why it has been delegated to suit. My lord, kindly see. Next, this is the important witness Tarunnath Mitra.
Yes.
Now, my lord, this second witness is Tarunnath Mitra. My lord, he was in the box and he was cross-examined. My lord, kindly see. In 107, page 107, his witness, he summoned the witness.
Yes, must have.
He came to the box. Anything asked will be treated as an examination in chief. Whatever may be the question. Only exception is, my lord, after examination, if the learned advocate finds that the witness is a hostile witness, in that case, leave to be taken from the learned court under section 154 of the Evidence Act. For what purpose, my lord? The purpose is to ask questions as it is being done in cross-examination. It is not cross-examination. Lord, treating this examination as cross-examination is absolutely beyond all the procedure of law. This is cheap.
Yes.
Now, my lord, Mr. Mukherjee could have persuaded the court to proceed in that manner.
Did you ask?
Though I have tried to draw attention of the court.
No, did you ask for permission to cross-examine that witness?
Yeah, I'm not crossing. He has. Oh no, I cross-examined. In that at that juncture there was difficulty.
So even if it is mentioned as cross-examination, if you crossed, then might be looked into as
no,
chief.
no. I'm just drawing on Lordship kind attention. When I prayed for cross-examination of the witness,
You must have taken the objection that there cannot be further.
vehement objection was
Just
there,
turned down.
and I had to come here.
But you ultimately won.
And thereafter,
So Mukherjee did his duty as a counsel.
his duty is to lead the court in a proper manner also. Nowadays, after getting this manner designation, his responsibility has.
No, it does not operate retrospectively.
My lord, no. Well, at this age of the practice, my lord, is relevant, my lord. Well, I cannot say, though I am senior to him in practice, but I cannot. My lord, behind my lord.
Anyway, let us look into what Tarunnath Mitra said.
Yes, very interesting. Now, my lord, cross-examination. I have another house at Salt Lake, beside house number 231 Raspberry Avenue. Beside the house of Salt Lake and Raspberry Avenue, we have house of my family members. There are 4 flats belonging to us, our family members. It is a fact that I have connection with 6 houses, not a fact that I am actual owner of the 6 houses or flats. I know Achyut Ghosh and Babu Mitra. I know Manoj Kumar Jaiswal, and I know him since his birth. Presently, he is about 50-55 years. I know him for 50-55 years. The name of the father of Manoj Kumar Jaiswal is Prem Narayan Jaiswal. I know Prem Narayan Jaiswal in 1962. Manoj Kumar Jaiswal and Prem Narayan Jaiswal are still merchant. I am closely connected with Jaiswal family. I know Subroto Datta, Achyut Ghosh, Malay Datta, Anjana Mitra, Mukul Roy. I know all the persons since 1955 and 1960. Subroto Datta, Achyut Ghosh, Mukul Roy and myself were students of engineering at Sipur. We all are connected with group of companies. We all 4 persons were directors, and subsequently, where our 4 friends became directors. For our business purpose, we had connection with foreign company. We had connection with USA, Switzerland, and Japan for business purpose. We all the members used to look after the affairs of our company. Metal Engineering and Treatment Company Private Limited used to work for manufacturing machine parts. Then further, presently I am the owner in respect of 4 houses and rest 2 houses.
No, what was the insinuation that he purchased the houses with this illegally earned money?
Maybe, Milord, but I don't. We will not get it. Milord. We are apprehending so. We are reading. We are apprehending so. Let us proceed, Milord. We will not get it. Then,
Might have 10 houses even. Yes.
Then, Milord, my personal house is 231 Raspberry Avenue. Other house is situated at Vivekananda Road. One flat is in Elite Cooperative Society, Bidan Sishu Uddan, and one flat at Santiniketan. Last year, I went to London to visit my son's house along with my wife. It is a fact that that was summoned to appear before this court, but I could not appear because I was not physically fit. I cannot say as to whether I filed any application before the Honorable High Court regarding the rejection of commission petition. Any prudent man should not avoid process of court. One director of Medco Group of Engineers Private Limited is present in court. In 2007, said Medco Group Engineers Private Limited was separated. Presently, the 3 companies, namely Metal Engineering Private Limited, Starmate Engineering Private Limited, and Elastomate Engineering Private Limited, are with me. The Medco Group Engineering Private Limited, Steelmate, maybe Steelmate Engineering Private Limited, and Exumate Engineering and Allied Products Limited are under control of Subodh. Then, Milord. Further proceeding. Last year, I went to United Kingdom in the month of July, August, and thereafter I came back after 1 month. I went there to the house of my son. It takes about 30 to 45 minutes to go to my son's house from Gatwick or Heathrow. I cannot say how much it
How about this relevant, Mr.
immigration department from the airport.
My lord, he was continuously saying that he is medically unfit and he is unable to come to court. Your lordship would kindly appreciate, Mr. They will also agree that in this case, this witness gave evidence finally on a microphone. Loudspeaker was brought to the court.
Yes.
Why? Because he's saying I can't speak.
His speaking was not audible, man.
Trying to avoid.
Not audible. We used to ask him question going to very close.
Achha.
Anyway, that is not so. That is not the reason. Let us go to the.
No, Mr. Whoever cross-examined was very vindictive on him.
Mr. Mukherjee.
Yes. don't know.
I cannot remember how much it took to fill up the immigration form. At the time of leaving the airport area, I was not checked by any authority. It is not a fact. I went to the United Kingdom in the month of July, August, but thereafter I did not go to remember do not remember at this moment. I cannot work because my Parkinson disease. I know Kashibabu, advocate of this case.
No, so there was a story like this in Alipur going on that when the witness was asked who colluded with you, he named all the counsel of the other side. So that's well known.
I'm safe, my lord, fortunately.
Close call.
No, I am director of as many as 3 companies, namely Medco, Elastomate, and Stalmate. I have 40% share in Medco, 50% share in Elastomate, and 40% share in Stalmate. I cannot say as to whether the information of the 3 companies are available in net or not. I do not know about difference between FERA.
So let us not read the entire thing. I mean, if there is anything material which you consider to be against you, may go against you.
I'm not merely saying
his property and he goes to London and all. Yes.
My lord, 1 minute I am taking your lordship's time.
Yes.
My lord, nowadays, my lord, even before that, nowadays, going to anywhere in the world by air, no physical fitness is necessary.
Yes. True.
Wheelchair is there.
International flights, wheelchair was
always there, always there.
Most probably. I never traveled.
I visited so many countries with my wife who cannot walk properly. So my wife was taken all through by wheelchair.
So he has
My wife was taken. What do you mean to say that?
By wheelchair to the aircraft and other places.
Shantiniketan duplex flats, we are fed up with so much property. We are feeling jealous. So let us skip over this. So he has got a good number of properties.
Yes.
He is a rich person.
Rich person, right?
But how he became rich, it is not evident from this.
No, nothing. My lord,
Might be we should have crossed Subrata Datta also to know whether the company pays them well. We should have done that.
Well, he knows nothing. Why should I disturb him?
This goes on.
Well, this goes on, my lord.
No, he says at Bombay airport I used wheelchair.
Yes.
Page 112.
My lord, material portion.
Fira Fema
Page 112.
112 from not a fact.
112. My lord, Miley
At Heathrow airport I went from town.
Here in the middle.
I knew Manoj.
I knew Manoj Kumar Jaiswal and Ajay Kumar Jaiswal prior to the filing of the instant suit. The materials were purchased from them, but I do not know as to whether they have any manufacturing unit or not. They used to purchase from dealers. Manoj and Ajay told me that they purchase material from sale. I verbally gave order for purchasing. I was one of the directors when I was related with company. Exumate and Allied Products Private Limited is our company. I became aware of the amalgamation of the two companies, namely Exumate and Mageba, later on. Subroto Datto was one of the directors of Medco Group of Company. As many as 6 persons are directors of the two companies. I know Achyut Ghosh.
Who was Achyut Ghosh? He was one of the other suppliers.
No. In the company. Company personnel.
He was a director, but no more. At the time
Anyway,
of
he was.
So why Achyut Ghosh comes up so many times?
spontaneous.
I know Achyut Ghosh. He continued in company 1962-1996. Achyut Ghosh did not file any suit against me. I paid rupees 50 lakh to Achyut Babu prior to getting any document in connection with this case. This rupees 50 lakh was paid from company account. I paid the said amount of rupees 50 lakh because he said that if I did not give the amount of rupees 50 lakh, he would file a case against me. There was an arbitration. There was no document regarding any word. Mukul Rai is present in court today, and he has.
Mukul Rai is also one of the directors.
Yes.
Or the other Mukul Rai.
No, not that.
Thank God. Yes.
I knew the plaintiff used to supply MS plates, etc. to Exumate and Allied Products Private Limited. It is also a fact that the Exumate was amalgamated with dependent company. Today, I have come before this court with my wife, brother-in-law, and two office staff. Mr. Mukul Rai is present in court, but I have not brought him here. I know Mukul Rai for a period of 56 years. I cannot say as to whether this Mukul Rai is fully aware of the facts and circumstances of this case. Mukul Rai was associated with the company since beginning, not a fact that I am fully aware of the facts and circumstances and trend of the suit, not a fact that I siphoned money from the company. I have heard about the law of FERA and FEMA, not a fact that I have idea about law of FERA and FEMA at the time of filing the suit in the year 2010. I know Manoj Kumar Jaiswal and Ajay Kumar Jaiswal. They are partners of Trade Center. Sometimes they had business dealing with me at the time of filing of instant suit. I had relation with dependent company. At the relevant point of time, I was director of the dependent company. I know where the office of the trade center is situated. I do not have any idea regarding where the godown of the trade center is situated. Plaintiff firm is not a manufacturing organization. Generally, goods are purchased from outsider and the same are supplied to the dependent company. It is well, it is a fact. We have said, they are also saying. When the plaintiff supplies goods to the dependent, the goods are tested by the dependent company. At the time of testing the goods, I was never present. The goods were generally tested in the factory of Exumate. When the goods are found bad after testing, I was communicated. When the goods are found not according to the quality of the same, or taken back by the person who supplied the same. That is the position of
No, that may go in your favor because your goods are never returned. So you have taken a stand that the goods were accepted by them.
Yes.
So
yes.
this you may argue that this goes in your favor in a sense.
No, that is not the sole fact, but the series of facts will show.
No, this is one of them.
One of the.
Because we are trying to find coherence in an utterly incoherent set of
My lord, the
cross
factory
examination.
dependent company is situated at Rajnagar, Howrah.
Now, also that he says he transferred his share to Subrata Datta and Malaya Datta.
Ah.
I mean, that also may go in your favor because if there are so many allegations against him after
There
that.
be any financial dispute, my lord. How the dispute, what was the dispute, how it was resolved?
Anyway.
It's not coming out. No action taken either in court of law or by any mediation or any arbitration, whatever it might be.
That might have been the understanding that you have committed so many wrongs, so give your shares. That may have,
that was actually the thing.
that may be one of the
He was given an option that to face trial or
sell off your yes, maybe.
Actually, they are
I do
friends
not
for
know
so
whether
many
the
years.
state factory is existing there or not. Generally, the organization who constructed bridge placed orders for us. The orders of bridge company were placed in writing. Image angles are given to the exhumate or dependent at random by weight. We transfer our share to Subrudo and Maladatto on 1707. I resigned from the directorship. During the directorship, there was no suit pending before the Honorable High Court. Prior to that, I was one of the signatory of the checks of the company. I used to look after factory. There are 4 factories of 2 Metco Group, 1 exhumate and 1 of state. At state, eh? Anyway, I do not know as to whether plaintiff company demanded payment from the defendant company. I cannot say as to whether the plaintiff company demanded payment on 3rd June 2008 in respect of the bills and challenge between January 6 and August 2007. Not a fact that I passed fabricated orders.
Mr. Mukherjee apparently grew fed up of his own cross-examination after this, and when an advocate for the defendant was found, he should be absent.
Yes.
So is the defendant, therefore cross-examination was closed.
Closed. Cross-examination closed. Then there is also.
You come into the picture now.
In each and every step, there will be surprising steps taken by Mr. Mukherjee. My lord, can you see?
Why?
Poor Mr. Mukherjee. Why?
On the say,
Poor Mr. Mukherjee.
On the
Has he done a crime in coming and sitting here?
In my career, I have learned so many things from Mr. Mukherjee.
His only guilt is that he has said that he will argue after the Saraswati Puja. But that is being victim.
That I am not telling you.
Yes.
Then, my lord,
So let us try to conclude this matter. Yes.
Yes, then, my lord, cross-examination from my side.
Yes.
It was not done after a prolonged proceeding in the
High Court and all.
Civil Division. Then I was allowed to proceed. Then, my lord, cross-examination. The claim of the defendant that I acted in collusion with Magoya Company is false. Exhibit 4 series. These are the documents upon which we are relying. The supply of goods, challans and bills. Exhibit 4 series is being shown to the witness. This is false that myself in collusion with plaintiff have manufactured these documents. It is a fact that if Senvat is withdrawn or deposited, it will be shown in the account book and the documents relating to income tax.
Which they did not produce. Very good.
No document.
Because you took that point, yes.
Then, my lord, you will also kindly see the closed. Witness is closed.
Oh.
After these 3-4 sentences, the witness is closed. My cross-examinations are closed.
Yes, but then they again recall.
Again recall. All right. He has recalled. I am suffering from Parkinson's disease. I have difficulty in walking. I was separated from Exhumate, Allied Products, Steelmate and Metco Group of Engineering Private Limited. It is not possible for me to go through the contents of each document relating to account. The office staff used to check it out and they used to hand those documents over to me for obtaining my signature. I have heard the name of Trade Center. Trade Center used to deliver goods to us. The office staff used to put purchase orders with Trade Center. I used to sit in the office situated at Bibi Ganguly Street, Kolkata. Trade Center used to supply materials in our plant situated at Howrah. The documents relating to office were transmitted in my office situated at BB Ganguly Street, Kolkata. I did not reconcile the documents relating to the said supply. The trade center used to supply materials on our plant with the help of their own men. The goods were supplied through truck. I did not go through the weighman receipts and other documents relating to such supply. Any two out of these three directors, namely myself, Subroto Dotto and Mukul Roy, were required to put their signature on checks. It is their statement, my lord, on record. So not that he used to sign alone. Then, my lord, I cannot remember as to whether or not I put signature on the return of VAT. At this moment, I cannot recall what document relating to purchase are kept in my office situated at BB Ganguly Street, Kolkata. I cannot also remember whether Achyut Ghosh filed any case against me alleging financial irregularities in our company. I gave rupees 50 lakhs to Achyut Ghosh as he disassociated himself from our business. Such payment made in favor of Achyut Ghosh shown in our accounts and it must be kept in our office. It was not paid from his own pocket. It was, my lord, it was paid from the company. I know Manoj Kumar Jaiswal. Manoj Jaiswal. He is present in court. I had good relation with him. The father of Manoj Jaiswal used to visit our office to submit bills. Prior to issuance of checks, I did not go through the relevant documents relating to such payments. Store-related documents were signed in our office situated at BB Ganguly Street, Kolkata. I used checks of United Bank, Bobaja branch. No work of fabrication, designing, and engineering work was done in the office situated at BB Ganguly Street, Kolkata. Only account-related jobs were done in the office situated at BB Ganguly Street, Kolkata. A bill dated 28th of January 2006 from Exhibit 4 series is being shown to the witness. This bill does not contain the signature of any office bearer of our company. I know all the staff in the office situated at BB Ganguly Street, Kolkata. A challan dated 28 January 2006 out of Exhibit 4 series being shown to the witness. I do not know who signed the said challan. Not that anybody put their signature on the challans. I also cannot say whether this particular challan was submitted before me or not. A challan dated 30th January 2006 out of Exhibit 4 series being shown to the witness. Someone from factory signed on it. At this moment, I cannot recall his name. At Exhumate, we manufacture steel parts bridge. A challan dated 30th Jan 2006 out of Exhibit 4 series being shown to the witness. I do not know whether the signature appearing there is of Ashish Das or not. I know Ashish Das. I do not know the educational qualification of Ashish Das. None of the bills carry the signature of any staff of our office. Bills. A challan dated 15th of May 2006 is being shown to the witness. This challan bears the signatures of Rajkumar Noskar. I do not know who issued the bills on behalf of Trade Center. It is difficult to ascertain from the bills as to actually sign on behalf of the Trade Center. A challan dated 8th of June 2006 is being shown to the witness. I do not know whose signature appeared there on behalf of Trade Center. As far as I remember, Robin Mukherjee and Ashish Das and Kishore used to look after the accounts. So far I remember, they used to check and verify all the bills and challans of the accounts related thereto. I was not the sole authority to issue checks on behalf of the Exhumate Allied Products Private Limited. Not a fact that I had no personal knowledge as regards delivery of goods in our factory. Well, this is contrary to the case made out. This suggestion is absolutely contrary to the case made out by the other. I do not know not a fact that I had no personal knowledge as regards delivery of goods in our factory. You want to suggest that you know nothing about the delivery of goods. Not a fact that I have not made any search personally to come out at a conclusion whether the goods are supplied to our factory or not. We used to manufacture bridge parts out of the goods which are supplied by Trade Center in our factory. At Exhumate, we used to manufacture expansion joint. Not a fact that the plaintiff has instituted the suit in collusion with me. The plaintiff kept contact with me prior to giving my evidence in suit, I did not train myself regarding the fact of the case. No further cross-examination by me.
Hmm.
No, I'm not making any grievance out of it because there should have been a chance for my client to cross-examine at this point. Because after recall, I have got the right to cross-examine.
We don't know whether you asked for that.
No, I'm not making any grievance out of it. All right, as it let it there as it is. But the chance was not given to me. That's why
This will be available from the order sheets only. ট্রায়াল কোর্টের অর্ডার শিটস দেখলে পাওয়া যাবে। আমি জানি না, আমার মনে নেই।
তাহলে ছাপা হয়ে যেত।
আমার মনে নেই, অর্ডার শিট দেই
কিছু অর্ডার থাকবে যে আমি করলাম না, cross-examine, etc. Anyway, these are the witnesses. Now, my lord, let us go to the, my lord, regarding the judgment, my lord. On the very first occasion, I tried to draw your lordship's attention to the judgment. My lord, the judgment was based upon only on single point that the partnership was not registered. That is the only point, and it is not so that that issue was decided against my client, and thereafter the suit was dismissed and other issues were not gone in. But here other issues were gone into. But ultimate conclusion was, since the suit is not maintainable, no finding on that issue. Now, my lord, so my lord, kindly, in my prayer, my lord, I will be saying, my lord, rather I will be praying, my lord, that your lordship need not go into the judgment cited by both the sides regarding the maintainability of the suit, because since we have got, my lord, the registration papers, my lord, consider it whether these papers proves that the partnership is registered or not. If that is not registered, my lord, the same fate will follow here. If it is registered, then my lord, the other issues have to be taken into for consideration. Now, my lord, for this,
Mr. Dey, according to you, if we find in your favor regarding registration, then
my submission will be, my lord, then to look into the materials on record and pass it.
order 4124. So materials are sufficient for us to pass.
Order 4127.
The 27 is a document.
No.
Additional document. No. My lord is asking about
document. You file additional document.
What's it?
No, that has to be considered also. Rule 27 is different. Order 4124 is. Yes. Order 4124, where evidence on record is sufficient, appellate court may determine case finally, instead of remanding it.
31 is also.
Order 4133 is there.
Power of appeal.
4133 is there. 33 is on a different point.
Yeah,
33 is there. Yes, yes.
That is very open.
33 is there.
And that is overriding 22 also.
Right. At least circumscribing.
Yes, circumscribing. Right.
We will continue then tomorrow. Then we will keep it as it is.
Yes, yes.
Hard learned counsel for the appellant in part. Full stop. Let the matter be listed tomorrow for further hearing. Already parted. It is parted since long.
Yes, yes.